all here for particle physics, right? I apologize for not changing the slide. I got up late. And actually, I'm doing this very slide for the NAV show in 4 days, next Tuesday. 3 days? I don't know. Somewhere in New York. Is there anything anyone has any burning need or desire to talk about with regard to intellectual property or any of that's like fan art, anything? Like I can tailor this to hit whatever it is you guys want to hit. So is there any particular area of intellectual property anyone is especially interested in or concerned about? On what? Fan art. Okay. Uh, that one's real easy. It's infringement. That one's real easy. Yeah.
I'm curious about making your own intellectual property and then how to negotiate once it reaches a point of being sellable to either a publisher or like another studio that wants to buy your intellectual
So
property.
that's more in the lines of contracts. I will spend a little bit of time on that if you want, but that is not what they wanted me to do this year. But I'll happily take some time and talk about it because I think it's important. And the question was about contracts and how to license your own IP. If Alan is okay with it, right after this class, Alan Panical and I are literally going through a license agreement I wrote for him.
Sitting here with you for like the next
So,
like 5 hours.
so if Alan's okay with it, maybe we could actually like take a half hour and do the anatomy of a license agreement.
That would be amazing.
I'll talk with him about it, and that way he won't have to get billed for it. All right, so let's start talking, and we'll go. Who am I? I'm just some guy they found in the street. I've been doing this for a long time. I've been an audio engineer for a long time too, so I actually come at this from a creative side as well. My wife and I, and our partner Brian Stillman, who's wandering around with the camera, we make documentary films. So we did the Eye of the Beholder, The Art of Dungeons and Dragons, that is going to be screening in here tomorrow. So not only am I an IP attorney, but I'm also a creative. I also do the same shit you guys do. I've been in bands for. Perhaps I look like I might play in a band. And there is my website. Here is your legal disclaimer. I am not your attorney. You should not rely on anything I say to your detriment or otherwise. Unless we have an engagement letter, I am not your attorney. Let's make that very clear. I am not your attorney. I'm not licensed to practice in Pennsylvania, Nevada, New York. I am licensed in Maryland. However, I do have clients throughout the world, and here's the salesman's pitch. I am happy to have you guys as clients if you want to hire me. The being barred in a certain state is being able to appear before a judge, and if I ever appear before a judge, I am the defendant. So I do not do litigation. So why do we do this class? Well, guess what the main product of the entire entertainment industry is? Yeah, that's the product, right? Whether you guys know it or not, you are involved in the entertainment industry, and the main thing that it makes is intellectual property. Movies, music, the list is exhaustive. There are so many types of intellectual property: databases, architectural drawings, ballet. Of course, then we get into the whole, rich white men make the laws, because why is ballet copyrightable but not urban dance, right? Here's a fun one. Somebody handed that to me for their comedy show at Gen Con a couple of years ago, right? No, you cannot make advertisements for your product by going and finding an old cartoon that somebody really owns the intellectual property to. That's infringement. That is a perfect example of infringement, right? Here's a good one too. So I run sound for my friends' bands every now and again at clubs. And my friend Steve has this band called Stoneburner. They are a Dune-themed EBM band. So a lot of it is, Arrakis, Fremen, blah, blah, blah. And I recorded a live show for him one night. And there are no good samples of the Fremen shouting, Muad'Dib, Muad'Dib, Muad'Dib. So he had the whole crowd chant it because he knew I was recording the show, so he could use it later. And then he looks at me and says, holy shit, can I use that? And here we go. Let's see if it plays back, if it likes me. Nope. I'm going to change it to my laptop, and you're just going to have to listen through my laptop. Because, where's Benny? We checked it, and it worked earlier. Here we go. Everybody be quiet. I give you permission to use this sample. So that is the entire crowd chanting, I give you permission to use this sample. Now, that hasn't been tested in court or anything, but, we're at a place where that would probably be okay, right? You get the first pass. Everybody else gets something thrown at them. Maybe take it outside. All right. So, what is intellectual property? Literally, IP refers to creations of the mind. That's what it is. It is a creation of someone's mind, someone's intellect, someone's knowledge, someone's creativity. Things like inventions, literary and artistic works, designs, symbols, names, and images. And this last used in commerce bit, it's going to show up over and over and over again in our discussion. Because we live in the United States, and if you're not using it in commerce, well, who cares? If you're not making money from it, then oh well. It's capitalism, right? Capitalism is ingrained and embedded in our culture, and part of this is whenever you're trying to protect your own intellectual property, you have to be using it in commerce. When I go to file a trademark for someone or a copyright for someone, if I can't show the trademark office or the copyright office that it is being used in commerce, I cannot get your mark registered or your copyright registered. You can't just say, hey, I created this thing. Okay, well, what are you doing with it? If you aren't doing anything with it, I can't copyright it or trademark it for you.
Can you do that before you sell it?
Well, you can do it in tandem. And what people normally do is they have their website go live, or they have, if it's a big business, they'll have SKUs, they'll have things that are going out to wholesalers, and that's a way to prove that it's being used in commerce as well. But usually you just put it on your website and have it for sale on the website, and you link there, and then they can show it's being used in commerce. Here and then here. And by the way, keep asking me questions because this gets real boring if it's just me talking for an hour and a half. So where did I get here first in there? Go ahead.
Maybe possibly dumb question. What about when you're potentially selling through websites like Buy Me a Coffee, where it's hey, what do you think, instead of
That's still commerce.
still considered commerce?
Yeah, I mean, you're still going to make some money from it. Yeah, there are certain things that aren't. Like, I just got a rejection from a podcast, and they're like, "Well, podcasts are not. It's not a service. You're not selling something to people." I'm like, "Yeah, you actually are." I one time had to explain to the Copyright Office what a role playing game was. That was fun, right? Like, you've never heard of Dungeons and Dragons, really? Anyway, so yeah, and then here and then there.
Yeah, so I guess not trying to be a smart ass here.
Be a smartass, please. If you make me laugh, you win.
If you're not selling your fan fiction or your fan art, does that
We're going to talk about that later. We will have very in-depth. Commerciality is one of the four-pronged tests for fair use, right? But it's one of four. Just because you're not selling it. If I paint Spider-Man, and it's the worst painting of Spider-Man ever, and I hang it in my bathroom, the painting of Spider-Man is the infringing act, not the selling it, not the showing it to people. The creation of that thing is the infringing act.
so like whether or not people will prosecute that infringement is like more important.
No. We'll talk about it later. There's a whole section on that, and we'll get there. Up over here, then there. Back there, here, then there.
So, is it therefore considered a commercial act if you're making an image to promote your service, you're not selling that specific image?
Yeah, that's perfectly fine. If you're promoting, if you have a service like your design shop, your portrait studio, absolutely, that brand name, do things like that. Is that?
Yeah. So, like, as somebody who's trying to get illustration work, you end up doing a lot of portfolio imagery
Absolutely. Who's next? You and then you.
So it used to be when I was in college, I said if you change something by 50%, it's yours.
How much is 50%? That's the question. That phrase is meaningless. That it's meaningless in the same way that that dude that just submitted 300 changes to his AI art to the copyright. What does that mean? Like, right? So that's kind of meaningless. You have to show real, and it's a sliding scale. You have to show real human creativity that you did something. We'll talk about the four-pronged test for fair use. Can you speak up just a little bit?
I run a student publication, and we go around copyright a lot because like a lot of students in the West Bay aren't honestly that can be published. And like we had like a copyright infringement sent to us a couple like weeks, like days ago.
Yeah.
It was like from 10 years ago.
Yeah.
It was on a website.
Yeah.
They make no money.
I'll bet you it was Higby and Associates. Was it Higby and Associates that sent you? So they're one of the biggest. So there are companies out there now, and it's funny. You guys as artists should love this. You should love that Higby is out there. They have an algorithm that trolls the web for infringing images, right? But it turns out that a lot of creatives are the ones getting hit by Higby for like, oh, I found that image online and I used it in my blog. I found that image. No, if you did not create it, if you did not license it properly, it is infringement, and you're going to get hit with a takedown notice, a cease and desist, or whatever. I have had many clients who get hit with these things from these IP trolls, and the answer is sometimes it's fair use. Like sometimes I can make that argument, sometimes I can't. Oh yeah, everybody thinks everything is fair use. Right? Like we'll have a very nice in-depth section about that. Thank you, sir. Can you check on the audio up there? It didn't work when I just tried to play it.
No. Okay. Let me go back.
All right. So, hey, I made it to slide 7 before we got bogged down. That's awesome, though. I love that. These things really do work best when they turn into conversation. So, keep the questions coming. I will skip some to say we're gonna touch on a big section on this. Main forms of IP, it's divided into 2 main categories: industrial property, things like patents, trademarks, industrial designs, and geographical indicators. We're not going to worry about these. They don't mean anything. And by the way, don't worry about taking pictures of these things. If you come up and take a card, I will send you this slide deck. I'll just email you the PowerPoint. Copyright's the second. It's the big one. Performing artists in their performances. And this shows you how old the law is. Literally, this is still the law of the land. Producers of phonograms in their recordings. That's still the law of the land. And broadcasters in their radio and television programs. Remember, it is not the broadcaster, the newscaster, it is the company that owns that IP. Just people have this weird idea that, like Carlton and the Carlton Dance, even if it came out that Alfonso Ribeiro owned it, it wouldn't be him. It would be the producers of the show that would own that IP. Copyright's second main form. It covers literary works like novels, poems, and plays, films, music, artistic works like drawings, paintings, photographs, sculptures, and architectural design. There have been a couple of Frank Lloyd Wright houses that have shown up in lawsuits because people just thought they could drive by and film it and use it in their films. Like, no. What kind of rights? What do we mean when we say you have an intellectual property right? Right? They're just like any other right. They allow you, the creators or the licensors, the people that license or create a certain form of IP, to benefit from your work or investment in a creation. That last bit, the investment in a creation, is important because, I can make a documentary film with a small group of people, but there's no way I'm going to make, an A-list action Hollywood film without investors. And guess who owns the IP in that instance? Yeah, the investors. Right? I mean, there are certain directors that might be able to own the IP, but no one in this room, and I submit to you in this state right now, that is one of those directors. Why do we protect IP rights? Here is the traditional sort of aspirational values. These are why. And this is writing from our founding fathers, right? This is the stuff that founding fathers said about why we want to do this. The progress and well-being of humanity rests on its capacity to create and invent new works in the areas of tech and culture. The legal protection of these new creations, it encourages the people who did this to commit more and additional resources, right, for further innovation. In a lot of ways, we're talking about the patent side of things here, right? I mean, one might argue that, hey, we should probably devote resources to eradicating diseases because we're human and ethical, but no, we do it because we want to make those companies make more and give them more money so they can make more. And here's the last one. The promotion and protection of IP spurs economic growth, creates new jobs and industries, and enhances the quality and enjoyment of life. Coming to the 3 o'clock, where we're going to talk about how AI is just obliterating jobs and opportunities and the enhancement and quality of life. But these are the reasons that we say why we protect IP in the United States. If we do it right, if we do this the right way, we do this efficiently, equitably, it helps everybody to sort of exchange ideas, exchange culture, exchange products. And hopefully it helps strike a balance, and this is Supreme Court language, between the interests of innovators and the public interest, providing an environment in which creativity and invention can flourish for the benefit of all. Some might say very, very long copyright protection terms only benefit one company. Talk about that later. How does this benefit the average person, right? Wow, that's fine print. I really should probably make this slide into 2. Hopefully, we want to reward your human creativity and endeavor. We want to reward you for being creative and exploiting that in the marketplace. And by exploiting, I mean actually like using it and making money, not in the bad way. Here's some examples, right? The film and recording industry would not exist and just make their own version of Star Wars. What is the incentive for Lucas to make another Star Wars movie, or now Disney, right? If anybody could just go do it. There's no incentive to protect, to really create anything other than the drive to create. Again, you have to remember, our entire country and our entire intellectual property and legal system are founded on capitalism. So that's where all of this, like at its root, all of this is to promote capitalism. All right? Yeah.
How did they skirt by with Spaceballs?
So we will absolutely, I have an entire slide on Spaceballs.
It's parody.
Yeah, there's a 4-pronged test for fair use. Okay, you're allowed. There's a 4-pronged test, and one of the exceptions. And by the way, I'll repeat this again later. Whenever anybody says to you, "I have a right to fair use," you absolutely know they're talking bullshit from the get-go. That phrase is meaningless. You have an exception to someone else's absolute right to control their works. Fair use is an exception to somebody's right. It is not a right that you have. So when somebody starts talking like that, you know they really don't know what they're talking about. They're an internet jockey. Like they've done their research on the internet. So more examples. Without the rewards provided by the patent system, yeah, it even hurts me to read that one aloud. Like, hey, maybe we should invent drugs to save human lives because we're ethical and great human beings. But no, we do it because, obviously, if we didn't protect their rights, no one would create drugs to save human beings. Like, all right, yeah, okay, whatever. It's a good one, right? Like, if we didn't protect IP, I would have no way to know without the little apple on the back, right? If anybody could just slap it on there, how do I know that this isn't a piece of junk that's going to fall apart tomorrow? It may still be a piece of junk that's going to fall apart tomorrow, but still, I know that that's Apple because we protect IP and no one else can put that on their product. Right. I'm going to skip right over patents because we don't care. No one in this room will ever get a patent, I assume. I can't imagine you would unless you are programmers doing something crazy. All right. If you're going to take one picture, go ahead and take this one because people don't often remember the difference between copyright and trademark in one slide. Here it is. Copyright. Think about what the words say. Literally, it is the right to make copies of something. The only person that can make copies of something is the person that has it's real. Just think about the words. The trademark is the mark of your trade. The Nike swoosh, right? The ears, which are also copywritten. I know, right? Just that's the difference between copyright and trademark in one easy to digest piece. Copyright is the right to make copies. Trademark is the mark of your trade. Trademarks. Distinctive sign that identifies certain goods, services, products, whatever, produced by an individual or a company. Its origin dates back to ancient times when craftsmen would put their signatures or marks on their works or products of a functional or practical nature. You know, the mark on the bottom of your sword was made by, you know, Decius Maximus down the street, who was a great swordsmith. And you know you were getting a good sword when his mark was on the bottom of that sword. That's literally where trademark comes from. It's been around for centuries. Oh, there's my note about blacksmiths in the Roman Empire. The first trade in the 1600s, or sorry, the 1200s. Nestle's got the first one in Hong Kong, and Avro Paints has the first. And that's why the beer is so bad, because it's been the same since 1366. I'm not a Stella Artois fan, but it different strokes. I don't like beer in general. I'm a bourbon freak. Yeah. All right, trademarks continued. Over the years, they've evolved into our system of trademark registration and protection. Hopefully, want based on what we're hoping to buy, right? What does trademark protection do? It ensures that the people that own the mark can enforce it, can make sure that other people can't use the mark of your trade, right? Let's go into a little bit more detail on that. The period varies around the world, but generally trademarks can be renewed forever. Copyrights they expire eventually. We have Disney to thank for the fact that copyrights are like 130 years now. But trademarks can be perpetual. All right. So if you have a business, and you know, one of the reasons we want a trademark is when you retire, and hopefully you want to retire someday, you want to sell your business. You know, your production studio, your whatever it is you've got. The mark of that studio can be transferred to the new owner, and that's valuable. That has real economic value. Like when I have so half of my business is creatives, the other half is tech companies. And when one of my clients is exiting, when they're getting bought by a larger tech company, there's tens of thousands, if not hundreds of thousands of dollars wrapped up in how valuable is this trademark? How knowable is the mark of your business in the industry? So we want to make sure that, yeah, somebody's going to pick up that mark. Somebody's who bought it. Do you know? It was probably some VC company.
I forget. It's a known company, and I forget, but they're using the name.
Yeah.
But they bought it.
That doesn't surprise me at all. It's legally enforced by systems around the world, and mostly we have the ability to stop infringers. But like China doesn't care for the most part. I don't even. If any of you were to ask me, should I register for my trademark in China? The answer is no. I mean, Disney can't even protect their trademarks in China. How are you going to do it? There are printing houses in China that right now today are putting out boxes of magic cards that are indistinguishable from real magic cards, except for the serial numbers on the packs. Utterly indistinguishable. Hologram down to everything. China just doesn't give a shit. So don't even bother trying to protect your IP in China. What kinds of marks can you register? This is a fun one. People really don't know. They can be a combination of words, letters, numbers. Right? You can have a Roman numeral or something like that. They may consist of drawings, symbols, or three-dimensional signs, such as the shape of packaging goods. God help you if you try to put those racing stripes around your figurine package. Your head will spin with the speed with which you will receive a cease and desist letter. Right? Do not try to put those racing stripes around your packaging. Non-traditional marks. So in many countries, you can register all kinds of non-traditional marks, like holograms, motion, color, or non-visible. Hershey's, chocolate, Chanel No. 5. You better bet that those things are trademarked and copywritten. Right? The Colonel's Secret Recipe, Coca-Cola. Why do we protect trademarks? Again, you know, hopefully they promote industry, enterprise worldwide, and we want to reward the people who own those marks, who have worked hard to build those marks into something recognizable. with some economic profit. It also hopefully hinders the sale of counterfeit goods. Fan art is a counterfeit good. just saying. And hopefully, we've got people with skill and enterprise, and we're enabling them to market the goods, the services that they create in the fairest possible conditions. This is why, Google is getting hit, or Amazon is getting hit with so many lawsuits for anti-competitive behavior. They'll see a product that works well on their website, and they'll literally just rip it off and have somebody in China make it and sell it under a white label, whatever. It's happening. Let's see if we got the audio working again. To take a little break and let you guys watch something fun, I have to switch the audio back over because I played the first one out of my computer. Did I hit it? Did I hit it? But hold on. Nope, nothing. So I'll play it on my computer. It's actually pretty loud. You guys should be able to hear it. Hold tight. All right, hold tight. Nah, this is the last one. I won't worry about it. Just be quiet. Maybe you'll be able to hear it. So there we go. That is copyright in one little. So that's Baden at Bucknell University for the Electronic Freedom Foundation. It is it is. I love it because it is fair use describing fair use. Right? There is nothing Disney's lawyers can do about that except have an apoplectic fit. Right? It is educate. It fits every definition that we'll talk about in a minute of fair use. It's educational. It's transformative. They didn't do it for money. So, that copyright one slide, like we saw in the thing, is the exclusive legal right given to an originator or an assignee, so someone you assign the right to print, publish, perform, film, or record literary, artistic, or musical material, and to authorize others to use the same. That is copyright in one slide, right? It is the right to make copies. Any questions? Cool. What does it cover? Novels, poems, and plays, reference works, newspapers, advertisements, computer programs, and databases can be copywritten. Films, musical compositions, choreography, paintings, drawings, and photographs, sculpture, architecture, maps, and technical drawings. There are more. So there are a lot of things that copyright can cover. The holder of a copyright can authorize or prohibit its reproduction in all forms, including print form and sound recording, public performance and communication to the public, broadcasting, and its translation to other languages. This was a huge deal when 5th edition Dungeons & Dragons came out. There were Chinese versions, Russian versions, and German versions that had not been approved by Wizards. Somebody just took it upon themselves to translate the book and sell it. And hundreds of thousands of them were on the market. And its adaptation from novels to screenplays, comics to movies to whatever. All right. Fan subs. Anybody involved in that community? Anime? Yeah, those things are crazy illegal. Yeah, I've seen people get escorted off the floor at anime conventions for trying to sell fan subs. Yeah.
Going a little bit back to D&D, what's the deal with tabletop game mechanics being free to use, but turns in an IP of a game system
So
being copyrighted?
That's an entire seminar in and of itself. You cannot copyright unless there are ridiculous mechanics in a game that are copywritten.
Yeah.
You can't copyright your game system, right? It's a book basically, and other people can write books like yours. But I submit to you that you should not have a game that has strength, intelligence, wisdom, dex, con, and charisma as their prime stats with hit points as their thing. You know, like don't do that because you don't want to poke the sleeping bear. Like if you're going to be creative, be creative. You can do something that isn't, you know. And here is the big one with regard to fair use and things of that nature. We'll talk about it again in a minute, but it is always a question of law. It is never a right that you have to fair use. You can always be dragged into court by the intellectual property owner and forced to defend your exception to their intellectual property rights. And it's 99% a case of even if you win, you lose, because you've just spent $50,000 to try a lawsuit to have a judge say, okay, your exception's good. Proceed. Like, okay, you've just lost half the budget for your film or whatever it is you were trying to do. Great example of that is Super Size Me, the documentary about McDonald's. The investors were smart. They made the producer go out and get a rider on his insurance policy, and the rider was against a lawsuit from McDonald's. Otherwise, we never would have seen that movie because it would have just been tied up in court, and he would have spent every penny he had to defend that lawsuit. And by the way, you can get riders for things like that if you're actually doing. Business insurance is something you guys all don't think about. If you're going to start a business, you need to do two things: form an LLC and get business insurance. And I'll do that class probably next year, the how to start your business. But we rotate. Like we do 1 year contracts, 1 year IP, 1 year how to start your business. But that said, yeah, business insurance, it will save you from so many things. It truly will. Like I was sitting on a panel just a couple of years ago with a filmmaker from Georgia, and they had a $50,000 red camera on a drone over a river. Guess what happened to the batteries in the drone while it was over the river? So that red camera, that $50,000 camera, is just gone. And yes, they had production insurance, but it's if you ever think it's not worth the expense, think of the worst thing that can happen. Like a kid comes into your studio and starts eating a thing of paint, right? Like you're going to get sued for that kid's hospital bills. Please get business insurance. All right. Assignment. Has anybody in here licensed any of their work before? So that's what you've done. You've functionally assigned the copyright in that work to someone else. Right? You said, okay, I am letting you be the holder of this copyright for whatever we say in our contract. Many types of works protected under laws of copyright and related rights require mass distribution. There is no way that I'm going to be able to distribute my film, right? Even if I can make it myself, which Brian and Kelly and I, our Magic Gathering documentary is going to come out in a couple of months. There is no way I can distribute it. I can't, right? So I need a distributor to get it into, streaming platforms, on airplanes, on trains, buses. You go to the hotel. Hey, it's a choice you can make on your pay-per-view. I can't do that myself. You need someone to do that, and I am assigning my copyright in that movie to my distributor to be able to do that. If you've ever had a book published, you have assigned your copyright in that book to your publisher to be able to actually have the book made and sold and distributed to stores. Yeah. So we'll talk about that again in fair use. A documentary film is literally the definition of fair use. It is educational. It is newsworthy. It's reporting on something. It's factual. It is. It's all. If it hits every exception to intellectual property, we'll talk about it in like 3 slides, I think. Hence, so basically, like we talked about, creators transfer their things to people that are better able to commercialize the value of what it is they've created. Make sense? What are the limits on copyright? This is the beginnings of fair use and limits. So, the law gives copyright holders certain exclusive rights for a limited time as an incentive to create works. Hopefully they're going to enrich society as a whole. We want you guys to keep making creative things, right? We want our culture to advance. We want creative energy in our world. In exchange for what is essentially a limited monopoly, it's what it is, the law expects that you're going to enrich society by contributing to the growth of science, literature, and the arts. It does not give total control. They transition to public domain after a set period of time. Here's how long it lasts. In the US, if you create the work after 2002, 70 years after the death of the author, right? So if you create something today, 70 years from today, it expires and the public can use it. Yeah. So if the work is of corporate or company authorship, 95 years from publication or 120 years. You can thank Disney for this one. It used to be 70 years. But when the mouse was about to expire, they lobbied Congress and got this extended. Yeah. Look, I'm pretty clear about the fact that I'm relatively liberal and anti-corporate, even though I'm a corporate attorney. I bite the hand that feeds regularly. But there are a whole host of arguments against these things. Like, look, these terms don't really enrich society. They enrich one company. Well, actually 5. 4 of them are pharmaceuticals and one of them is Disney. Yeah. 100-year monopoly is pretty excessive. It doesn't really contribute to anything other than the wealth of that company. It's insane. 100 years. Everybody, every single person alive when that thing was created is dead. Here we go. Exceptions to copyright. What we're doing right now. Right? I can use any copyrighted material I want because I am showing you what copyrighted material is. I'm educating you. Education is the biggest exception there is. Now, that said, I cannot sell an education book that contains a whole bunch of people's copyrighted written material in it. Okay? Just copyright is not easy. Fair use is not easy. Please do not ever think that, unless you've practiced for 20 years as an IP attorney, that you know fair use forwards and backwards. It is fraught and it is dangerous, and you will get yourselves in a lot of trouble with cease and desist letters and even lawsuits. So please, I'm $3.50 an hour, and 15 minutes of my time is worth you not getting sued by Disney. Virtual instruction, pretty much, and fair use. Here we go. It's a limitation and exception to somebody else's actual copyright. All right, copyright holder to use some or all of the work, even if the copyright holder refuses to or doesn't Um, I did take the Spaceball slide out, but here's where I talk about it. Look, Weird Al and Mel Brooks have always sought permission. Right? There are Weird Al songs we've never heard because he didn't get permission, even though he absolutely could have done those parody songs. Absolutely. He just didn't want it to. Why poke a bear when you don't have to? If you're that creative, I'll just write another song. You know. Spaceballs. Look, you have to. There is no way, right, when you're creating a parody, that you can't use a whole bunch of Star Wars material because you have to use the material that you're parodying for it to be a parody. We'll talk a little bit more about parody in a second. Why do we allow it? This is Supreme Court language. By carving out a space for creative uses of music, literature, movies, etc., during the period the work is protected by copyright, it is intended to help reduce, if not relieve, the tension between copyright law and the First Amendment's guarantee of freedom of expression. And I love this last one. Breathing space for new expression within the confines of copyright law. So we want to protect your copyright, but we also want to have this space for new expression, for parody, satire, for parody and satire are very powerful forms of political dissent. And that's what really the founding fathers and our initial Supreme Court justices were thinking about when they wanted to protect. Back in the day, it was illegal to have, you would get arrested and thrown in the tower for actually posting a parody or satire of King George. Like, literally, that was an arrestable offense. Yeah, they very much do, yeah. Oh, and by the way, just to be clear, everything I'm talking about here is, for the most part, U.S. law. There are different requirements, different laws everywhere in the world. But if you have a specific question, perhaps I can answer it. But for the most part, this is all you. Yeah, go ahead.
What if somebody from a different country copies your painting and then sells it off?
So that's an interesting. The question is, what if somebody from another country copies your painting and sells it either as an original painting or prints or whatever, right? So there is this thing called the Wassenaar Treaty, Wassenar, and it is a treaty of many countries around the world. I don't know exactly how many, but it's a good chunk of them, that we agree to respect the intellectual property laws of the countries that have signed this agreement. China is notably not a signatory. But again, you know, it's a treaty. So, okay, I'm going to try to enforce a treaty law in another country. Enforcing your intellectual property rights in another country is ungodly expensive. I can't do it. I don't know that anybody in here could. So my recommendation is, if it's happening in the United States or someone in the United States has done it, good, pursue it. You know, I can help you pursue that. But if it's a print farm out of China that's just churning out copies of your prints and T-shirts, okay, shut them down. Another farm's going to pick it up. Like, print on demand is awful. Amazon is awful. Like, all these places, oh, we're just the marketplace. You know, no, it's not our fault. Somebody's posting infringing stuff. It's really rough. If it's Europe, I mean, the EU is pretty good. Like, most of the European Union countries are signatories to the Wassenaar Agreement. So we can have a chat offline, but it's not cheap.
It's not me. I'm just curious about a situation.
Yeah, functionally, you would want to hire an attorney who deals in intellectual property in the country in which this is happening. If there are better, different options, yeah. No, they will not accept anything unless you are the copyright holder. Nope. It's awful. All these sites they're literally, they only exist to siphon money from you. No, because it's not your copyright. You have to prove to them that you own the copyright. And by the way, the Digital Millennium Copyright Act is just a joke, right? I can help you do a cease and desist letter, but here's what happens normally. Somebody infringes your copy. Let's say they rip you off and they've posted your video on YouTube, right? So you get in touch with YouTube and say, this is infringing. And they go to the person that posted it and say, all right, this other person has claimed that this is infringing. Will you take it down, or are you claiming that you own it? If they claim that they own it, YouTube has no further responsibility to you unless you show up with a lawsuit against that other party. So Did that other party actually use a real name, address, and whatever when they posted that video? Can you find them? Are you going to hire a lawyer to file a lawsuit against them? And then you can go back to YouTube and say, see, look, I'm suing them. Take it down. It's horrific. The DMCA doesn't help anyone except for huge Fortune 500 companies who can afford to basically either say, this isn't a person that I can find, and they have the clout to get you to take it down anyway, or to actually file a lawsuit. So, yeah.
So I make dams for great different designs and for a very niche market, but I'm in Pennsylvania, a company that makes it's in Virginia, and I'm an outside contractor. So I went to my Pennsylvania lawyer and I'm like, this is what I need, this is their contract. They're like, I can't discuss it with you, gotta go get a lawyer in Virginia.
That's ridiculous. All right, we should. Why did they say that? Because they didn't know Virginia law? So contract law is pretty much the same everywhere, right? And yeah, no, that's they just didn't want the work or something.
In this market, if I make a garment, my competitors are making it 6 months from now.
Absolutely,
There's no
yeah.
copyrights.
Right?
But I get the money when I sell the design.
Yeah, it's. What are you hoping to achieve? Like, what are you trying to achieve?
I was independent contractor making designs, but also doing all their marketing for that niche.
You should ask for a shit ton more money.
I was getting $35.
That's not terrible, but it's not awful.
Right.
But capitalism bad. A lot of the things we're going to talk about today really boils down to capitalism sucks for anybody that's not rich.
Right.
And I don't think anyone in this room has not heard that or doesn't know that intuitively in their bones by this point. You know. Here's how a court decides. Go ahead. Was there another question, or were we just all chuckling about capitalism bad? If you're going to rely on a fair use exception, right? If fair use is something you're going to use in your work, be careful. Here's what a court looks at, right? Every case is different. Looks at the facts of the specific use. It's decided on a case-by-case basis after looking at these 4 factors. They're in 107 of the Copyright Act. Here's the examples. Purpose and character, right? Have you transformed? This is where every creative falls. Oh, of course I've transformed. I've transformed it. What was it? Somebody made the comment, I've transformed it 50%. Somebody said that earlier, right? Like, what does that mean? That's meaningless. How do you prove that you've transformed it 50%? No. There was an awesome, I should really put it in this deck, picture I took at a Comic-Con a couple of years ago of a painting a woman made of Boba Fett walking into a bar with Waldo and Carmen Sandiego and that monkey sitting there hiding from Boba Fett. Like, where in the world is Carmen? How do you find Waldo? And it was cute. It was funny, but it wasn't transformative. It didn't use them in a new and interesting way. It wasn't a comment on society. It was just an infringing piece of art. It was cute, but it was an infringing piece of art. So there's a slide on this later, but let's talk about that. It is, again, capitalism bad. Do you have a lot of money and can you hire a good law firm to make that argument for you, right? In a lot of ways, the best thing you can do is political satire, social commentary. What is your painting of Carmen Sandiego hiding from Boba Fett really saying? Like, how are you commenting on society or making a social issue or making a statement? Using that intellectual property in a way that is different from the original use of that intellectual property. Yes, it's cute. Yes, it's funny, but it's not different. It's the same use. Yeah.
If Boba Fett looked like Frankenstein.
Then it's Frankenstein, not Boba Fett. If you combine them, you have Boba Stein.
Yeah.
Okay, what is your social commentary? If you can make a good argument, maybe you do have a fair use exception. I'll show you an image that I think never should have gotten it, but the social commentary was. We'll get there in a second. So this first is the purpose and character, and it combines the commercial nature, right? The transformative quality or commercial nature? This is the question that people, oh, but I'm not selling it. Okay, but that's just one part of the test. Even if you make Spider-Man, this beautiful print of Spider-Man, and give it away for free, the creation of that painting of Spider-Man is the infringing act. Second is the nature of the use of the work, right? How are you using the copyrighted work in your product? How much of it did you use? Amount and substantiality, and the effect on the potential market or value of the copyrighted work. Those are the four-pronged. That's the four-pronged test for fair use to see if a fair use exception applies. So we'll talk about that, right? Parody and satire is a great exception. News and education purposes, like we discussed earlier, and public figure right of publicity. If you are a public figure, you have less rights than normal people do because you are a public figure. That's why we don't have to get a release from Biden every time we take a picture and put it in the newspaper. Yeah.
What's the threshold of public figure?
Beats the hell out of me. Are influencers public figures? Are famous artists public figures? It's a case-by-case basis, right? And if a good bright line distinction, and it's not really a bright line distinction, but a good way to think about it is if something you do can put you in the news, then you're a public figure. And by news, I mean the newspaper or not a Reddit news channel or a Twitter news channel, right? Purpose and character. Here we go, right? Let's talk about this. Divided into transformative and commerciality. Is the work, is it the same as the copyrighted work, or have you transformed it in a new, different way? This is where all creatives that I know fall down. It is, right? Here's the best example of this. Google search engine. It transformed Getty Images. Is it Getty? Yeah, it was Getty. Into searchable thumbnails. Getty sued them. And the court said, sorry, let's go back. It was highly transformative since the entire usage. Getty had images for sale. Google's images were literally transformed into these things that helped people buy Getty's images for sale, right? This is going to bite us, by the way, in the AI world, this ruling, but I'm not going down that rabbit hole. Jeff Koons, this is the one that I think the court got wrong. This was a comment on models and eating disorders in America. And he literally just took a bunch of Gucci photographs from women wearing sandals, Gucci sandals. I don't know. I like to think I'm a creative, but that just, I don't know. The court said it was transformative enough and it qualified, so Gucci lost their lawsuit. It does. It looks exactly like a foot fetishist. Yeah. Anyway. Commercial or non-commercial? Are you going to make money from the work? This is half of one of the four prongs of the test. Do not think that this is the whole test. A lot of people do that. They think, well, if I'm not selling it, if it's not commercial, then it's fair use. No, that's not the case. All right. Again, commercial uses can still be fair. Spaceballs, right? Parody can still be a fair use. It's something the court will take into consideration. Biographer of Richard Wright, right? Quoted from 6 of his unpublished letters and 10 unpublished journals. And this is literally an article that was published in the newspaper. This was the book. The court found the biography was fair in part because the guy wrote this book to inform. This is the news exception, right? We want to learn about Richard Wright, okay? And it only used 1% of his unpublished letters. That is, again, I hesitate to include that because then we start getting into changing it 1%, using it 1%, right? But functionally, they used less than, I think they used like 6 letters out of 600. This is the Betamax. And literally, Sony sued saying, you're going to destroy the videotape industry if you let people copy things from one videotape to another. And the court basically said, look, if you record it from television, right, it is a fair use. Obviously, you can't resell it, but just making a copy for your own, and this is why you can make mixtapes, because if you own the thing, you can make a mixtape for somebody. Can't sell it, but you can make it and give it. That's the commerciality part of it too. Okay. Not only that, but they got paid by commercials. The TV channel got paid by commercials already. So they're basically saying something you gave away for free, you can't say people can't use it for free. Nature of the copyrighted work. It's more likely to be fair when it is factual rather than creative. If you copy somebody's creative work, that's generally going to be a problem. If you copy someone's factual work, well, it's a fact. Did you copy their work or did you just copy the fact? Okay. So here's 6 Seconds in Dallas, and a book publisher used several stills from the Zapruder footage of Kennedy's assassination, right? So the book was called 6 Seconds in Dallas, and the owner of the footage, Zapruder's estate, filed for copyright infringement. Court ruled the publisher's use was fair and reasonable because not only was it based on an actual historical event and factual, the news exception applied as well. Amount and substantiality. How much did you use, right? If you copy the heart of something, that's going to count against you. And don't ask me what the heart is because the Supreme Court waffles, we really don't know. In a lot of ways, it's why people like me have a job because intellectual property law is wishy-washy. How much is too much is always going to depend on the purpose for which the work's intended, right? Parodies have to make extensive use. Robin Hood, Men in Tights, Spaceballs, Scream. Here's a good example, and plus I love anything that makes fun of Scientology. The Washington Post used several quotes from the Church of Scientology texts that were posted on the internet. Court found these to be fair because the newspaper used only a tiny amount of them, and literally they were reporting on these things that the Church of Scientology put out into the public. So that was absolutely a fair use. Effect on the market. I want you to look at that. This applies even if the original is given away for free. So if you use something with a fair use exception and that original was given away for free, you don't get to use it with a fair use exception just because the original was given away for free. Okay? If you use copyrighted work in this way, in a way that takes market share away from the original market holder, that's going to be a huge problem, right? As long as you serve different markets, you're probably going to be okay. No one's going to go looking for a copy of the Carol Burnett Show and mistakenly buy a Family Guy episode. That's not going to happen. Yeah, and then I'll come over here.
So does that, how does that apply when there's stuff out there that might be, for example, published under Creative Commons licenses?
So if it's a Creative Commons license, the first question is which version of the Creative Commons license? Have you read the Creative Commons license? Do you need to give attribution? And can you use it commercially? I've spent a lot of time in the Creative Commons world, and just because something has that Creative Commons license doesn't mean there's not a whole bunch of strings attached to it. Yeah.
Can you elaborate on taking away market share?
Yes.
What is market share and how would something get taken away from it?
All right. So look. That sucks. I'm sorry. Campbell's soup, right? Think about Andy Warhol's screen print appearance of Campbell's soup cans. No one is going to walk into a supermarket and say, I'm very hungry. I'm going to go, oh, hey, I think I would rather, in the market, I would rather this Andy Warhol painting than some soup, right? That painting is not going to take market share away from Campbell's soup cans, or Campbell's soup, right? But let's say, this is a great example. The Beatles record label, guess what it was called? Apple Music. Guess who had to buy that for hundreds of millions of dollars from the Beatles estate, from the Beatles, right? Yeah, Apple bought it for a lot of money. So if you are going to have your record company be named Apple, and there's already an Apple out there, or Apple iTunes and Apple Music, yeah, that's going to take market. People might actually confuse those two in the marketplace. That's what we're talking about. Anything that would cause confusion in the marketplace that would say you're going to buy my product over their product. Yeah.
So there was this really stupid lawsuit a while ago, like I don't know how long ago, about like two erotica authors.
Oh, I know about yeah.
And like
Oh, slash fic.
yeah, well, it's not even slash. This was like heterosexual. That was just fucking pinky, and it's like one of the authors was just like saying, or like she like claimed stupidly that like she's destroying the market for my book by writing a book in the same genre. How would that like be interpreted?
I mean, it didn't. It isn't.
Yeah.
That's like saying, no one else can write. Everybody's got to pay Tolkien to write a fantasy book. That's idiotic. So, and obviously the lawsuit got dismissed. But at the end of the day, and honestly, people often file spurious lawsuits for notoriety, for press. And I'm 99% certain that's what it was. It was just somebody being shit, wanting to get their name in the press, and I'll bet you their sales of their book went, skyrocketed. Any other question? I think I saw another.
May I have your card because I gotta go to portfolio review?
Yeah, just grab one on your way out here. All right. What time is it? How much time have I got? 2:02. Oh, good. I got a little bit of time left. All right. Episode of Family Guy made fun of Carol Burnett. No one is gonna mistake those two. Like, if you're gonna go look for an episode of Carol Burnett because you want to watch a Carol Burnett show, you are absolutely not gonna go and find that. You got it. Right? Nobody's gonna mistake those two. It's not gonna get confused in the marketplace. Here's the warning. They're guidelines, okay? Guidelines. Courts are most interested in whether you made a good faith effort to try to license it to begin with. And you'd be surprised. I have tons of clients who reach out and they're like, really? You're just going to let me use that? Yeah, sure. Or, I don't know, give me $100. Like, seriously, you can often find like something you think is just utterly unattainable. If you don't ask, you don't get. Right? It does you no harm to ask, to give, to let somebody. I need a drink. It does you no harm to ask beforehand and say, "Can I use your intellectual property?" Oftentimes, the answer will be yes. This one I include because there are lots of people out there who are just looking to cash in, right, on somebody else's IP. We are approaching the end. The Wind Done Gone is a great example. It is written from the perspective of the black folks in the Gone with the Wind. The estate of Margaret Mitchell sued Randall for publishing the book, right? Houghton Mifflin, on the grounds that it was too similar to Gone with the Wind. And it is scene for scene, conversation for conversation, Gone with the Wind. But everything that's not dialogue is what's taking place in the minds of the black folks in that book, in that story. It attracted numerous comments from leading scholars, authors, and activists. The reason I include it, right? Court of Appeals vacated an injunction, so they said, okay, the lower court said, no, can't do it. Can't publish the book. Higher court said, okay, yeah, you can publish the book. We're going to vacate the injunction, right? And then the case was actually settled when Houghton Mifflin made an unspecified donation. The reason I do this is we don't have an answer. We don't know what the real answer is because they settled. And it kills me because that's what's going to happen in this AI case. What's going to happen is a whole bunch of rights organizations it's going to be like Spotify. Bands make nothing. They make nothing off when they get streamed on Spotify. I see the writing on the wall. So we're never really going to get this visceral, this nice conclusion like, I'm in the right. It's not going to happen. And that's why I include this, because nobody really knows what the real answer to that question was because they settled. Here's the fair use parting words. Always a question of law. Always, always, always. Again, if somebody says, I have a fair use right, you know they're talking out their ass because it is not a right. It is an exception to someone else's absolute right to control their work. You have a fair use exception, okay? And it is also a case of, even if you win, you lose, because if you get dragged before a judge and they say, Okay, yeah, great. You have a fair use exception here. You just spent $50,000 for that judge, basically, and you can go on with your life, but half the budget for your project is gone, right? Um, this is a huge one for both filmmakers and people that are writing novels and comic books and whatnot. Uh, if you have fair use in your products, your distributor is going to raise holy hell. They might not distribute your product. They're going to push all the risk back on you. And here's a fun one. For people who are making animation and for anything that's going to go in another product or for filmmakers, you've got to get what's called E&O insurance, errors and omissions insurance. And you have to explain and get an attorney's opinion letter why this is fair use. And if you lie about where you got it, or did you ask for permission, or was permission denied, blah, 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 not only are you in breach of your contract with the distributor, you know, there's infringement issues, you have also committed insurance fraud. So just be real careful about fair use. I end this one again. That fair use tale was Professor Eric Faden at Bucknell University. And look, it makes Disney lawyers, it makes them lose their minds, which is why I show it every time I can. This was, Benny's asleep, so he's not going to see that this slide is actually for NAB and not for IX, because I'm doing it again next week in NAB. Oh, did you? Yeah. All right. Thus endeth the lesson. Any questions? I'll sit here for the next hour and ask. Start here and then come down.
So how does all of this affect, say, an artist that uses a pseudonym or an alias to market and sell their work?
So your pseudonym or alias is trademarked, right? So that, because if it's not, then anybody can just use that pseudonym or alias to do whatever. And if they do something awful, unethical, whatever, that then comes back on you. It really doesn't change your requirement to comply with law. Like just because you're using a pseudonym doesn't mean you don't have to comply with intellectual.
But would the trademark of the name then be sufficient protection
For
artistic works produced under that name?
I don't know what you mean. Like what are you protection from what? Like are you saying you want to use infringing things and
No, the opposite. Like I don't want somebody to use my work.
Oh, you absolutely need to trademark your name. And what I recommend to all of you guys, by the way, is if you do a body of work every year, on your website, publish an ebook at an exorbitant price. No one will ever buy it, but every year you do one copyright filing for your ebook. And that covers every piece you made that year. Everything, yeah, like do an annual book of my work every year, and that's the filing you make at the end of every year. That way, all of your stuff is copywritten each year, and it's just a good habit to get into. That said, I really need to put a slide in here about this. The moment you create something, the copyright's yours. The moment you make it, you can put that copyright symbol. Absolutely, right? What happens is that R in the circle, the registered copyright, that's when you register something with the Copyright Office and get granted the copyright, that's when you put the R in the circle. But you can always put the TM, or the copyright, the C. Make sense? You had a question? No, come over here. No?
No, you kind of answered it.
Okay. And then up. Yeah.
I'm looking to publish, and I'm still caught in between whether or not I should publish independent or with distributor because of, you know, the fact that a distributor will then have the rights to publish my work and only them. You know, you can't print and sell your own work, only they can. And
it's economies of scale. Go ahead, finish. I'm sorry, I didn't mean to.
But anyway, this is maybe a little bit more simple stuff, but just wondering, like, if I have an IP and I'm worried about putting it out in the public, even like concept art of it, when is a good time to like register copyright or set up protections so that no matter what happens, I am covered, I guess.
We're back to the whole capitalism bad concept, right? Like, if you are an independent artist, everything in the deck is stacked against you, right? You have no choice but to put your work out there because you want to make money out right? But the thing you're asking me is, how can I protect my work if somebody rips me off? And the answer is with money, right? Because you have to hire an attorney, you have to do cease and desist, you have to maybe litigate. The answer for a lot of people in your situation is go with the distributor because you will make more money than you would, and
Get more eyes on it.
right, and that IP will become associated with you and with your brand,
I see.
right? Just hire me or someone like me to negotiate the contract with the distributor. Those things aren't no contract except for like your bank contract and your telecom contract and your cable contract and your power, like your utilities. Nothing else is written in stone. Everything else is negotiable. Everything. So don't ever think that you get a contract, you can't negotiate it. Just don't do the thing that a very, very famous artist client of mine did. I'm not going to tell you who this is, but you will laugh if you knew. They thought that if they just crossed things out, they didn't apply in the contract. Like, no, you still signed it and sent it back. The other side didn't agree to those things you crossed out, so they're in there. Don't do that, right? Like, if both sides initial next to those crossouts, then okay, both sides have agreed to that. But trust me on this one. Don't get somebody to look at your contract with the distributor, and they will tell you if it's a good deal, a shitty deal, or everybody takes this deal. It's bad, but everybody takes it, right?
Understood.
I do two different kinds of work, and one kind is more commercial oriented, and I was told by a copywriting company that it's very expensive to get your work copyrighted, and so the artist, who is the main person, was saying that only get it copyrighted if you think it's going to sell. But you're saying
So think about it, right? Like one filing a year, that's not ruinously expensive.
Right. Well, I've never heard that. That's like brilliant. But so if I put, even if I put like my fine art and my commercial work in one book together, I could, all of that work is registered copyright.
Yeah. Just make an ebook, right? A PDF. And not only does it help you, it helps me when I go to do your filing because you send me one freaking PDF. That's the only thing I have to upload to their website. I do the filing. And there it is. All your stuff is there for them to look at. And when they go to look, is it being used in commerce? It's on your website as an ebook. Yeah.
Why make it, you mentioned make it ridiculously expensive.
Well, I mean, do you really want somebody to have, high-res copies of all of your work? Maybe you do. Yeah, right? But, I mean...
But it doesn't, like, if they buy that and they use that, like, that doesn't change the law.
No. Yeah, I usually tell people make it ridiculously expensive because every now and again someone will buy it and you'll be like, oh, yay, it's Christmas. Yeah. Yeah.
So what's the difference between copyright law and a patent?
Patent is for inventions, right? These are we're talking about creations, and inventions are literally I'm not a patent lawyer, by the way. Patent lawyers are rare special snowflakes. They have to take a different bar exam. They literally have to take a patent bar exam. They are usually very technically minded. They usually have science degrees or math degrees. And patents are for new and inventive ways to do a thing, to make a product, to make literally a better mousetrap, to make a car, to make a circuit board. So it is a way to protect the person who invented that thing. So inventions are different than creations. Here, and then down again. One of you two. Somebody go.
So you might have mentioned it already, but I might have missed it. How do holidays work in the whole contract? And I remember
Holidays?
Yeah, like Disney, I think tried to trademark Day of the Dead recently.
Yeah, that's not like if it's the title of a film, maybe, but you can't just. There's no way to. Yeah, you can't copyright a holiday.
No, I get that. So how does that fit? Because it's a public thing, but it's recognized by the name, like Valentine's Day or Christmas. It's just not.
No, it's not. It's not copyrightable.
There is a big thing with Taco Tuesday. Did you hear about that?
No.
That was really big.
I mean, there's another guy, and we're late on a reply, and he did it as a mental exercise, but it also questions everything there is about intellectual property law. He created an algorithm that created every possible combination of 8-note melodies and submit it to the Copyright Office saying, here you go. Thereby basically saying no one else can ever copyright any melody ever again, because this is every combination of 8-note melodies that can possibly mathematically exist. And they haven't ruled on it yet. But and it wasn't just the algorithm. He actually had the algorithm play out all of those melodies. So he actually submitted a file with all of those melodies, and it was like this monstrous file. But we have no idea what's going to happen. It's going to be this crazy thing. Like I'm assuming they're going to reject it for some reason or another. But yeah, right. So you go ahead. Yes.
Yeah, so I'm just very curious. I worked, like 3 years ago, I worked on an NDA project
Okay.
where I.
But so hold on for just a second.
Yes.
Raise your hand. Has anybody signed an NDA for a project? All right, cool.
Yeah.
Good. I'm just curious. I just for my.
Yeah. And I still, I work for a smaller studio that works for a big name company.
Right.
And I still am not allowed to say what the project
Yep.
was or who the company is.
Yep. I'll bet you it was Pixar, or Disney, or Blizzard. But anyway.
But,
Yep. That's okay. You don't have to.
Basically, they're still working on the project.
Sure.
And I'm not allowed to. I want to put it on my resume.
No.
No, I know. I'm not allowed to mention it. They said until it comes out, but more recently they said I might never be able to disclose it.
Well, what does your contract say, right? Like that's the first thing I ever do when somebody wants to hire me or has an issue. I'm like, pull up your contract, and 9 times out of 10, you guys don't have it. So please, by all means, that's another like word of warning. Make sure you keep your contracts and make sure both parties have signed them, you and the other side. And make sure they're not Word documents, please, PDFs or JPEGs or pictures, something. But that said, yeah, like I without looking at your contract, I can't tell you if that's a real thing that might happen to you, but I know it happens all the time. Yeah, I mean, yep, happens all the time. I mean, there's like literally, I know, like people I was drinking with yesterday have magic cards that will never see the light of day, and they can't talk about, they can't show pictures of, they can't. Sorry, it's just in the slush file. Maybe someday they'll publish it, and I can talk about it. And someone who's not here this year, right? Someone who's not here this year has an oil painting, like this huge oil painting in the slush file, and he's like, "This should have been a $20,000 piece for me," and I can't even tell people about it. So, yeah, NDAs they're par for the course, though. Has anybody in here done work for Blizzard, Activision? Don't. I'm dead serious. So John Shindehedi, you should come to his talk tomorrow. Absolutely, John is an amazing guy. He was the art director for Wizards for a while and art director on D&D 5th edition. And he literally told me he's had clients who've complained to him that Blizzard does not put rounds of revision in their contract. You work and redo it until they're happy, until they say you're done. Not like 1, 2, 3, 4, 5, 6. Until they say you're done, you're going to revise that piece of work over and over again. It's awful. You had a question over here?
Yeah, quick one about that one, actually.
Sure.
Could that artist hypothetically make significant enough changes to that oil painting for it to be...
No. It is, I mean, maybe, but why would they do that? Like, it's a gorgeous, beautiful piece of art. And when you sign that contract, like, Wizards knows. And your art director at Wizards, there's only a couple of them, they're going to know if you sell that painting publicly in any way. If you sell it privately, maybe. But if you sell it privately and that piece gets taken out of the slush file, I wonder why it wasn't sold. They're going to have a question about that, you know? Let me do something. Any other questions, by the way? Yeah.
So, does it matter, like, I don't recognize 240 and I'm in Pennsylvania.
I'm in Silver Spring, Maryland, right outside of DC.
Okay, so you're in Maryland. Can I still use you? As a
Yes, I have
lawyer?
clients all over the world. What you missed in the beginning was being barred means I can't appear in front of a court that I'm not barred at. And if I ever appear in a courtroom, I am the defendant. Trust me, I do not litigate. I will never litigate. So if I'm ever there, somebody sued me for something.
So you would
No, it was a joke. Like, I got in trouble with the law if I'm in a courtroom. Anything else? Yes? Yeah, here.
Just a fun one. So, are cover bands considered the fan art of the music world?
So,
yeah, that is-
most bars and restaurants have an RAA, not RAA, CSAC or ASCAP. They pay a fee to be able to play music, and it covers cover bands. Think about it, right? Wedding venues, they have to pay that fee because of the cover bands that play there and the music that gets played. There's often a back and forth because there are certain venues that don't pay that fee that make the DJ pay that fee. But that's like, everybody's like, well, why? I can play this. And it's why you can't have Super Bowl parties. Like, that's, you paid to have that channel and you paid for a private use. Like, if you have 50 people over, every 50 person, all of you were supposed to pay to watch that show. That's why bars that show the Super Bowl paid a shit ton of money to be able to pay to show the Super Bowl to the bar. Or they're just flouting intellectual property law. Sometimes they do. But it's interesting because there have been some cases where larger sports bars have been sued, and the cable provider gets subpoenaed to show the record of what was shown in that bar that night.
I have heard a lot more about copyright law in regards to music.
Yep.
And as far as I'm aware, compared to other art forms, it's a lot more lax.
No. It's actually a lot less lax because they have better lawyers. Like, literally, it depends on the band too. Like, if you're Metallica, you're going to pay for really good lawyers. And Sony is going to pay for their lawyers. Like, sorry, Sony has very good lawyers. Yeah.
I know with like certain like I guess like genres of music like jazz, like you're taking cues from other like musicians that have come before and other pieces and stuff like that. Would that count as transformative as well?
It depends on the case. Like, I would argue that it would. Did you sample it? Did you actually play it? How did you mangle the sample? What did you do to it? Being a musician myself, like I guarantee you could give me a piece of music and I can use it in something else, and I guarantee you won't recognize it. I'll chop it up. I'll distort the shit out of it. I'll phase it. I'll echo it. You won't know what I did to it, unless you have some sort of weird watermark in it, and a lot of music actually does nowadays. This whole, by the way, I love bringing up the music stuff. Who in here knows that Trent Reznor has a country music award? Who in here knows why Trent Reznor has a country music award? So listen, Pixabay. Anybody use Pixabay or any of those sites for like images and reference and whatever? So any image or art you find online that is free to use, come to our website. Those websites exist to serve you ads and make money, not to give you free IP. The producer for Lil Nas X's Old Town Road bought a bass drum riff off of one of those sites. And the person who uploaded to that site utterly lied, ripped a whole bunch of Nine Inch Nails samples and put them up there on the website. And the website, they're like, hey, you got to sue the person that put it up, not our website, not our service. We're just the clearinghouse. And that person just disappeared into the sunset. But at the end of the day, Lil Nas X's producers worked it out with Trent Reznor that, yeah, this is okay. Just, give me a nominal license fee. Well, lo and behold, Old Town Road wins a country music award. Guess who gets one? Trent Reznor.
How about bootlegs? When you're at a show.
Bootlegs are illegal. It's infringing.
Yeah. A lot of times though, the bands will say, yeah, go ahead. Like
I'm
Foo Fighters, like, for example, who has their own label. They don't care.
I keep telling them they got to put it on the back of the ticket. So when you buy your ticket, when you buy your badge,
Yeah.
right? I drafted the terms for IX that. So when you come here, you agree that they have the right to take pictures of you and videos of you and use those as they see fit. That's what happens when you buy a ticket to go see a concert, right? That you can show up as the person going in row 2, because when you bought that ticket, you agreed. So by walking around, if you walk around a Comic-Con, usually at a Comic-Con, the terms and conditions, the 2 things that are on the back are you give up all rights of privacy. We can use your image for anything, name, likeness, and And we can kick you out for any reason or no reason at all. Don't be a jackhole.
But what about the people who are filming the band?
So
They're
they're
in the audience, they're sitting on the rail, they're filming the band.
yeah, that's infringement.
Yeah.
You're not.
What if they get a lot of these concerts?
Oh, sure, it happens all the time.
I mean, there's stuff all over the place.
People are gonna care more as the tech gets better. Like the video is gorgeous now out of phones. Like literally, by the way, I'm streaming this live and recording it just so I have it, whatever. I'm using an iPhone as a camera because it is orders of magnitude better than any Logitech bullshit thing, right? So as the tech gets better, the audio is the problem, right? The audio is not as good out of mobile devices, but once the audio gets really good, like it'll be a problem for the bands. Right now, they don't care because the audio is shit on those things. When the audio gets a lot better, they'll start caring more, and you'll start seeing more takedown and whatever. There are actually certain locations that will block you from posting to social media during a concert. Like literally, if you are in this geographic area, you can't post because they know that you're literally just posting video of the show.
Yeah, I've had
It happens at Merriweather Post all the time.
Yeah, well, and my husband puts up bootleg shit of blues stuff. He's on this run with blues, and
Yeah.
he bootlegs a bunch of stuff, and like
I mean, functionally, it's all unless the band like.
Sometimes, like, it's a 3 strikes you're out thing. If they have
Well,
to remove you 3 times.
It depends on the band too. Like Fish doesn't care. Fish wants you to do bootlegs of their show. The Grateful Dead, they don't care. They want you. So it depends on the band too.
Yeah.
Did you have a question? And then I'll come back down here.
So, if
I went to law school with Melanie, by the way.
Hi.
Say I'm drawing in public.
Yep.
Someone takes a picture of me and my work, posts it. I didn't necessarily consent for this stranger to take this picture of me and post it online.
Mhm.
I also have the fear of being turned into a meme in our surveillance state.
Memes, by the way, memes are infringement. What are you going to do about it? Like, I've had clients that are like, I'm in this meme. And I'm like, there is no way. It is so viral. There's no way we can put that cat back in the box. It's impossible. But you personally, like if it's one person who posts the picture, you could absolutely do a cease and desist and take down. Right? Because they did not license that picture of you. And it happens all the time on social media. Like people just show up in the background of pictures, and that's no bueno. But again, capitalism bad. Because what are you going to do? Sue Facebook? Good luck. Anything else? I'll keep answering. Yeah.
So this is back to something else you were talking about. So trademark. So you're saying, so I have this commercial business.
Sure.
And I've revamped it. And I have an animation that I created to be a banner on my website. Is that trademarkable?
It's copyrightable the second you made it. Like it's your copyright.
Well, I know, but I mean, I also know just from having been in the business, people can steal your work and
Yeah.
you can't really go after it because of the expense. But what about a trademark? What's the difference?
Same type of enforcement method though. Like if you can't afford to go after someone for copyright, can't afford to go after someone for trademark. Like
But what can I trademark of that? Like, because that's my whole branding, right? The animation, the layout, the animation, and the logo is my branding.
how much of it are you trying to do? Like, is it an entire website? Like, it can't be something that people have to click through. Like, if it's just a page,
It's the banner.
yeah, you could. I would say you
logo
probably
and the
could.
banner.
I would say you probably could, but without actually sitting down with you, looking at it, and whatever, you probably could trademark that.
And how much is a trademark?
Trademark right now, I think, is $250 per class.
Per class? What's that?
So there are about 50 different classes of trade. It's why you can have an Apple fruit vendor and an Apple Music and an Apple computer. So there's a whole bunch of the intro ones are like industrial classes. You're going to be in like the 40s and above, like T-shirts, and tech products, entertainment services. But it's why you can have, like I said, an Apple fruit vendor and an Apple technology company. So per class, if you want to make T-shirts, that's going to be one class. If you want to control your brand on the internet with the service that you provide, that's another class. If you want to make mouse pads and posters, that's another class.
So if I put my logo on mouse pads and posters, does that change anything?
If you put then it's not the mark is not protected on those things because you haven't filed a trademark in those classes. So if you actually go to the trademark office and you look for Apple, they probably have 50 different classes. They have it on tech products, on T-shirts, mugs, like everything that you could possibly do with the Apple logo, they've filed a mark for.
Oh, so if I'm selling particular products using this logo, I would have to file a mark?
It depends. Like clothing, right? So you could T-shirts, sweatshirts, hoodies, jackets. That's all one class. Tech products, tech services, right? The services that you provide as an illustrator, artist, producer, whatever it is you do.
That's called a tech service as an illustrator?
Again, Illustrator wasn't a job when these classes were created 250 years ago,
Oh,
right? So it's some sort of service that you provide.
it's not an object, like if I'm providing illustration in a produced form, that's an object.
So if you're going to do it in books, books and literature is another class, right? Media, physical media. Then digital media is another class. I think that was created later. So yeah, there are many different classes of trademarks that you can file. And whenever my clients who are artists or game companies, I say, look, not only do you want books and games, but you absolutely want T-shirts because you're going to make T-shirts of your products. You want clothing.
So do you pay one trademark and then you add classes onto it? Or
It's
I mean,
$250 a class.
Oh my God.
Capitalism bad. I mean, it is what it is, right? Copyright's $100 now, I think it is for copyright. And there's no classes in copyright. It's just $100 a year, do your filing, get your book of stuff in every year.
And do we do that or do you have to do that?
You can do it if you want. I would recommend like coming to me or someone like me for at least the first one. I fully subscribe to the teach a person to fish method. I would much rather show you how to do it than like get email from the copyright office and charge you $350 an hour for it. All right, like that's boring as shit for me. I don't want to do that. So, yeah.
So I've been contemplating about whether or not I should start doing like copyright and trademarking now while I'm near the end of my schooling, or if I should wait until my name's going to change in the foreseeable future. So if I should wait until my name changes and then I do all the trademark and copyright stuff now, then, or do it now?
No, this happens every day. Like it's up to you how you want to do it. The name changes don't matter. You can always change your name. And honestly, what I would do is, for everyone in this room, please form an LLC. It's not that expensive. It's marginally. Be an LLC. Every year, it's going to be like $300 to the state. But what it does is the LLC is limited liability company. That is the thing that owns the art. So that way, it protects you from personal liability. If God forbid you ever create something unintentionally or intentionally, whatever, that gets you sued, they sue the company, not you. Okay? Not only that, but if your name changes, it doesn't freaking matter because the company owns that intellectual property, not you. Anybody else? And then you go ahead, and then anybody else.
The LLC, how does that complicate your taxes?
It doesn't. That's a great question, actually. Here's the point. An LLC, a limited liability company, is flow-through taxation. All right? Literally, the taxes of the LLC flow through to you. You file one tax return, the same tax return you file right now, and you add one form to the back of it. Profit and loss from a limited liability company that you own. Do not let some jackass accountant make you form an S corp. I have so many horror stories about it because what happens is when you are a corporation, even if you're a one-person corporation, you have to send yourself quarterly board minutes. You have to hold quarterly board meetings with yourself. You have to have records of those quarterly board minutes. And if you don't have all those things and you get sued and they try to pierce the corporate veil and sue you instead, guess what? They will be able to because you guys are artists and you're not in the business of sending yourself quarterly board minute notices and quarterly board minute meetings. You don't have to do, yeah, I know. You don't have to do that with an LLC. You literally file one thing a year with the state saying, yeah, I'm still an LLC. Here's my money. Never.
What was the question?
Sole proprietors. So a sole proprietor is what you are by law if you do nothing. It means sole proprietor. You are the proprietor of your business. You have unlimited personal liability. So if anything happens, you get sued, you lose your house, your car, your savings. Okay? Please, please, please be a limited liability company. I think in the rotating schedule next year is the how to start your creative business, and then the year after is the contracts class. But here and then here.
Are there any situations in which you would want to do those other things?
Yes, if you are clearing, if you are literally bringing in 250,000 or more a year, then you want to be a C corp. Here is the awful capitalism bad. In the United States, the laws are so good for corporations that it is more advantageous for you if you are making $250,000 a year to be taxed twice on that money at the corporate level and at the personal level than if you just had flow through taxation to you with an LLC and pay taxes once. That is how good the corporate taxes are in the United States. It's obscene. If you are making, if you are pulling in actually $250,000 or more, and if that's not a bright line, it's somewhere in that neighborhood, right? Could be 200, could be 300, depending on the state you live in. But it's actually better to be taxed twice because you'll end up taking home more money because corporate loopholes are so good. You had a question?
Kind of like what you were saying with Apple having two different blank classes.
Sure.
Say like you try to trademark like a name for yourself, like something cafe or whatever, and someone because it's like a very like common like.
You might not get the mark if it's that common.
If you can prove like if it's like both like two artists who have it, can you just like not get that and like have to change it or?
Yeah, I mean, if you file for a trademark, they're gonna do a web search, they're gonna do a library search, right? It is when you file a copyright or trademark, it's the Library of Congress. They're gonna search the Library of Congress for everything that's ever been published for things that are maybe conflicting. So you likely will not be granted a mark if someone has already been granted a mark. Make sense? So the situation where two people have a mark that is that similar, it doesn't really happen. Yes, dear.
Just as a point of interest, I have to run out for a second to find my child, but my cousin, I walked in when you were talking about Family Guy.
Uh-huh.
If you hear a voice on there that is somebody else that isn't part of the
main?
regular cast, that's my cousin.
Oh, that's awesome.
And he was actually sued by Morgan Freeman because
Because he sounded.
he is like this like total white bread white guy. Sounds.
Did he get what happened in the? So how did that play out?
Injunction. He can't do him anymore.
Really?
Yeah, and also Arnold Schwarzenegger, same thing.
Wow.
He started with Arnold Schwarzenegger.
So there's actually
So he has to call himself the fake Arnold Schwarzenegger if
that's
he does that now. But he does it a ton of voices, and Freeman he can't do it anymore.
That's funny.
Yeah.
My favorite case in that vein is the Chevy like a rock commercials. Anybody enough to remember those? Like a rock.
Yeah.
That's not Tom Waits, and Chevy got sued to hell for that by Tom
Huh?
Waits. Yeah,
Interesting.
So when it comes to like.
and I'll come right back down.
When it comes to like impersonators, like a live person, like that is like people like trying to do like impressions like this.
I mean, impression depends on what you're doing with it, right? Like if you're getting somebody to do that voice, and you're going to use the voice as a representation of that voice, that is literally taking market share away from the person who has that voice, right? Think about it. So yeah, but if you're just doing it as part of a comedy sketch, that's transformative. You're not taking market share away. When nobody's going to hire a comedian who does a bit about somebody when they really mean to hire that person, right? Yes.
So two questions really quick.
Two answers.
Is the trademark your name, like my company name and my logo? Like I did a web search to see if I could get this name on the web, which
Yep.
I can, but only because some Chinese guy bought it. But if I put a hyphen in, I can use it.
They might not give you that mark if it's already marked.
It's not marked.
Okay,
It's
then.
like they buy a bunch of websites,
Yeah, I know how that
that's
works.
what they do.
Buy it right now, by the way.
Oh yeah.
If you don't, people are watching those sites. Somebody's going to buy that in a couple of days if you don't buy it. I'm not kidding.
Oh. Okay.
Like, if you actually do web searches for, I might get this domain, people literally have bots watching those.
Oh. Wow.
I don't know. Can you talk about that?
Yeah, so there was actually a network solutions a couple of years ago started getting in trouble because potential
customers would use their search engine to see if this domain name was available, what they would do is when you buy a domain, you don't have to pay the register for 6 days. They would buy it ahead of time in hopes that you would buy it through them, and they got in trouble for that.
Yeah.
But
So that's what I'm trying to tell you. Like,
domain squatting is a huge thing.
Don't do the search until you're ready to pull the trigger.
And with domain names, one of the things I would also do is when you buy it, put a reminder or calendar when it, like a month or two before it expires. Because we've had a couple of folks in the artists here that they forgot, they didn't get the email, it expired, and then
Put it on auto renew.
Yeah.
Put it on auto renew.
Sometimes auto doesn't work. So,
Really?
Yeah. So a couple of folks lost their website. So
It's awful.
yeah. So,
What is it? Is it up to 11 characters? Like nothing under 11 characters is available?
I'm not sure. I know definitely like up to 4 characters, like it's all gone. 5.
I thought it was farther than that.
Maybe if you get like one of those like
Casey's gonna search.
.sy or those other websites.
What time is it? Oh shit! All right, we've been doing this for an hour and 45 minutes. One more question. Anybody?
Well, you didn't finish it.
Oh, all right, go ahead. And then one more if anybody's got one.
So your trademark, is that your name or your logo with your name?
Yes, it depends. I mean, you tell me what you want to file.
I want to file my logo and name, but I want to have my name trademark also, so that they can.
You're going to do 2 marks.
I'm sorry.
You're going to do 2 marks. Because if you just do, you want to do a plain text filing, that protects you from anything, but that's not going to protect your logo. Because it protects anybody ever using those letters in that combination, right? But if you do a filing that's your name and a logo, it stops somebody from using your name with a logo that looks like that. So you want to do both. And anybody else? Yeah, go ahead. You didn't ask a question. Great.
Say that like you like made a character design, you don't have like the money to trademark it, and then someone else steals that and trademarks it. How often does that happen?
I mean, it happens all the time. There was just one that somebody was doing a sketch on Twitch, and dude took a still, had AI finish it, and copyrighted it before the guy actually finished painting it on Twitch. Yeah, and it's talk about. I think there's a slide on it in the AI class next. But literally, just think about that, right? But he was able to show the copyright the Copyright Office that this is my video of me creating it, right? Like I have the video of me creating it entirely. So yeah, the guy filed it before I finished painting it, but that's how he did it. And this is me starting it on this, like, it shows me painting it like this. Yeah, the Copyright Office said, you can file, if somebody files something that is yours, you can absolutely file, a claim saying, hey, this was stolen from me. It takes money, though. Yeah, that's the problem. All right. Thank you, everybody. I appreciate it. I got to hit the bathroom, but stick around because we're going to start the next one in like 15 minutes.
As of 2 years ago, all 4s are gone. 5 are still available.
5 are still available. All right. Okay. You having fun?
I got a good nap sitting here, man.
Good. I'm glad.
Yeah.
Come and grab a card. Yeah, stuff, things. I am. Silver Spring.
I'm up in Baltimore. We're actually looking to set up states and our lawyers. What do you think about IP?
I will happily help with
Yeah.
states and IP and whatever else it is you need.
Did you need Jeff or else we can say anything?
No, I'm good. I think I can make it to dinner. I'm going to take my meds now. That'll hold me for a while. I got to hit the bathroom and I'll be back.
I was like, I gotta get
Yeah.
go to bed.
Oh.
Maggie's sitting out on the floor right outside.
Okay.
You can come in.
She's thinking about doing it.
Did you guys see everything yet?
Yeah.
What'd you say?
Yeah.
It's like
This
a coffee
is
though.
Had I
Whatever,
money,
whatever
it's
you're
lovely.
If you go over to my big purchase this year is over in Scott Fisher's booth. I bought his exsanguinate painting.
I got the other one.
You got the drawing?
I did.
That's awesome.
I mean, I would take a ton of oil.
Pineapple or roast nuts.
No, I'm good. I got a pee in the bag. I'm gonna pee. I'll be right back in.
Yeah, no, but I'm
Do you need
actually
anything?
gonna
I'm good. I gotta pee. I'll be right back.
All right, we're heading back to the room. So.
Oh, all right. I'll go with y'all.
Alright.
Yep.
I'm actually gonna go pick up.
Cool. Yeah.
Well, Kristen.
Oh,
Throw out.
I wanna go, I kinda wanna go draw.
Okay.
I would like you to sit down here. And you can play with your phone as much as you want. I'm just gonna do a little shopping. Okay? You're gonna buy me stuff. I might. But I'm also maybe gonna buy me stuff too. So we'll see. So we shall see. But anyway, I have another thing of water that I absolutely want. If you want more water, you gotta get it. Alright, I'll be right back.
That's my goal.
He's really good. Oh my god. He's like so good. He's like so chill.
Look at you. I don't know where Kelly is. I hope she's doing all right. She said she was having a bad pain day earlier. I'm gonna text her and see.
Would you be willing to send a PowerPoint over? I missed the
Oh yeah,
presentation
sure.
for this part.
Just email me about it.
All right, thank you.
Don't expect an answer for like a week because
That's
I got a lot of shit going on.
I won't
but-
need it for a week.
There she is. I was just about to text you. I hope you're doing all right. Where do you want to sit?
Where should I sit?
I don't know. Take a look at the screen there because I am recording it down here.
Oh, nice. Hello.
Not the phone, but the microphone here does. Oh, you're fine. You're fine. It is. Yes, it is already recording. So.
Gotta go retrieve some coffee.
Right.
A late night.
try. I was good last night. I only had like 2 drinks.
Yeah.
And by the way, that is AI generated. Oh. This would have been a very interesting in a bad way without the ribbon.
Oh man, I didn't nope, I left mine at home.
Do you need?
That was like,
It's they're 20 ohm tabs. If you're prescribed them, I'll give them to you.
for Adderall, not for
Adderall is actually a little heavier for me.
Yeah, I just do like a tiny little, like a quarter of a jab if I need it.
Benny, any possibility we could get her a water? Do you have anything else other than that coffee?
No, but just
If you talk, trust me.
yeah, I'm gonna need water. Thanks.
I forget how dry it is here.
Oh,
I woke up this morning like,
Mm-hmm.
and it's not like sick. It's like, holy shit, the air's dry.
Yeah, yeah.
So how did everything go last night?
Great.
Yeah.
Really good. Another great showcase.
Good.
Meeting. Got to see lots of people.
I made my table feedback, so that was great.
There you go. So tonight's gravy.
Mm-hmm. Yeah, exactly.
See if I can move over a little. I gotta eat you over. Hold on.
Okay.
Where are you? No, that's you're over there. So we want to go this way. That's the way we want to go. Oh, there's plenty of space. All right, and let's see if it works.
Oh, thank you so much.
Yay. Should put your name on there. I'm sorry, I suck.
I don't. You're fine.
Oh. How are you doing? We haven't had a chance to sit and chat. No, we actually stopped at like 12:30. Yeah.
Do you want to try to fix the audio before?
There's no audio on this one. Yeah. So we stopped around 12:30, bed at 1. So I actually was a responsible human fucking being last night.
Good work. Ordered.
We'll do it again tonight. You've got dinner plans? We're doing Italian. I know. We're trying to find Liz Danforth and I were trying to find a time to have breakfast, and we're like, no. Right, yeah. Well, we could have breakfast if we both want to get up at like 7:30. It actually wasn't bad. It was only like 5 minutes. Yeah. Oh, really? It didn't feel longer than that. What time is it? Okay, we got 5 minutes. All right, so is there anything anybody really wants to talk about? Because this is going to be fun. Right? Like, is there anything anybody absolutely wants to address? And I'll make sure we do. Yep. Yeah, it absolutely is. Like, there's no putting this genie back in the bottle. Like, capitalism. Hey, wait, who was in the last class? Capitalism bad. I think what's going to happen is the same thing that happened with the RIAA and Spotify and streaming platforms. And the thing is that, it's not impossible to retrain a database. It's just expensive. And what they're saying is they don't want to go through the expense, right? And
But we know they have the money.
Right. Of course
know
they do.
They
How
can
much
do it.
Microsoft's in for $10 billion at this point?
They can do it.
So, come on, hit me. We'll start with questions and then we'll get into it.
Just, I'm like thinking
Right.
But, so like, are we gonna have to carve out and create new businesses with this?
Yep.
With this stance and this. Yep.
Hopefully, there will be some legislation that protects you, but I'm gonna punt that to you.
No, that's a really good question. Yeah, what I'm seeing happening is there are companies popping up who are taking advantage of this and being like, "Oh, we want to support artists," and then they're like, "Here's an ethical AI generator." The truth is, it doesn't exist, not yet. So they're lying to you.
You're gonna laugh when we get to the ethically generated AI slide.
Oh yeah,
You
yeah.
really will.
Looking forward to it.
Really.
But yeah, we're gonna have to do our own due diligence to find out, which, companies we're wanting to work with are actually, honoring the ethical challenges and such. I've been hearing a lot of artists seeing that in their contracts, that they are signing and saying you're not making AI generated art, and that's an improvement. But
Making music, maybe your work won't be fed into that algorithm, but maybe it's like still being used in-house for certain use cases.
well, that's like, yeah, if you're licensing something, you're agreeing to that work being used for those purposes. Hopefully, contracts are now saying like whether it will be used to train AI. Hopefully not. Look for that.
Because AI is right now producing the worst shit it's ever gonna produce. It's only gonna get better.
Yep.
Right, and so. Sorry, I'm like.
You're fine. It's also risking feeding on itself, which basically just degenerates all of it anyway. And that's where a lot of these companies recognize that human-made art is extremely valuable, because without that, they're just, training on AI-made art, and that's just like a JPEG, and you save it over and over, and it just like falls apart. So, yeah.
Yeah, definitely this space is going to be increasingly more competitive.
Well, yeah, my thoughts on that is that it's probably easier now to become an artist than ever before, with the tools we have in front of us, many of them free. And yeah, so competition now is even even wider, because we now have AI art to compete with too, which is a big part of why I'm in this fight. Is like, we shouldn't have to compete with digital Frankenstein monsters of our own work. That's how I feel.
Are you an artist?
Yeah, I'm a part of the lawsuit.
There's a slide about that.
Yep.
Should we get started? Should we just dive right in then? Fuck it. All right, here we go. All right. Welcome to particle physics. Okay. So we start with this bit. I am not your attorney. You should not rely on anything I say to your detriment or otherwise. That is the one we have, right? Yes. Okay. I'm not licensed here. I'm licensed in Maryland. Basically, this is the I am not your attorney bit. Please, please, please do not think I am your attorney and sue me because I gave you advice that got you fucked. But I am happy to have you as a client should you wish to hire me. So I've been doing this for a long time, intellectual property law. I've also been an audio engineer for a long time and a musician for a long time. So I make documentary films with Brian Stillman and my wife Kelly. So I come at this not just from the legal side, but from the creative intellectual property creator myself side. That is my website. Who are you? So you're from?
Oh yeah, so I'm from Nashville. I actually just have one E in my name, but that's cool.
Oh, I'm sorry.
It's cool. It's cool. No worries.
By the way, that's how my wife spells her name.
Oh yeah.
So that's
no, I
probably
think we
why.
talked about that. Yeah. Yeah, I just started teaching. Well, yeah, I was going to talk a little bit about that. But so I've been a full-time artist since 2012. I went 11 years before I had to get some stable income. I have no idea if that's related to the proliferation of AI and that affecting my career, and the fact that over 50 of my paintings were scraped, stolen,
My name has been used as a prompt for tens of thousands of times, and I have seen my income take a dip. I can't say for sure if that's why, but timing's pretty suspect. So I picked up a teaching gig. I'm working with freshman art students in art college, and I'm very excited about that because I want to be a part of inspiring the next generation of artists and just making sure that they have a path too, like many of us have had, but they've never had to deal with AI, so a whole new world. Anyway, that's my work. I paint with watercolor and acrylic gouache. I've started making comics for Evanescence a couple of years ago, which is pretty rad.
I found that was the best one that I liked.
Yeah, thanks. Yeah.
And then here's the other little bit.
Yeah, so me, Carla Ortiz, and Sarah Anderson are suing Stability AI, Midjourney, and DeviantArt, and potentially others. We'll see.
Yay.
And that lawsuit went live earlier this year in early January, and it's been wild.
So we'll probably have time to talk about that if you guys have questions, and I will have questions about that.
Yeah, and if I can't answer something, I'll let you know. But
yeah, that's fine.
Yeah.
The key word here is NDA. Just say NDA, and we'll stop that line of questioning.
Love it.
All right. So I like to start with this little quote. If we're not arguing about this stuff, are we actually really having a real discussion about art? I know what I think, and I know what most of you probably think. Warning! Again, I usually have this in front of me, so I'm like, Kelly and I are literally just going to be doing this the whole time.
Yeah, I'm blind.
Right? It's a new area of law. Very little about what we're going to talk about has actually been settled by the courts, if any of it. We just don't know, okay? The terminology is fraught, right? Calling it AI art, just that word, right? AI art. Is it art? What is it? Is it a plagiarism engine? There's all these different things. So when we talk about it today, if I use the term AI art, I don't mean to give it this status as art. Just it's a term that we're going to use when we discuss things. And then, again, we know what we think, but we're kind of more concerned to hear what you guys think and what questions you have. Okay. So here's what we're going to cover: intro and warnings. We're going to do a brief high-level discussion of the tech. Then we're going to talk about ethical and legal issues. So what is oh God, I'm going to suspend you for a minute. I literally need to look at my computer for this. Oh. Otherwise, I'm just going to be turned around the whole time. All right. So, otherwise I must step on it. Okay. So none of this stuff, by the way, this isn't a batch product. It's not a process that's going to just push together pieces of images. It's not that, right? It doesn't reference the original training set, okay? It simply uses its understanding, right? The model that it has built through a series of network weights, and it's just a tiny fraction of the training data. It just uses these network weights that it has learned from the training data when it is creating a new piece of content. It does not trace. Okay, there are people out there who think it traces, that bashes together, that does certain things. No. And the cost of retraining, it is not easily or cheaply retrained, but it can be done. You will hear these companies talk about, it's just impossible. We couldn't possibly do this without. No, you couldn't do it without spending a lot of money. And the money exists. We were just talking about that, right?
It's like a $48 billion industry. They could do it.
Yeah, Microsoft is in for $10 billion at least. So where did the stuff we're talking about come from? GPT-4, yes. Does anybody know if they've confirmed GPT-5 yet? Yeah, it's probably going to happen. I mean, Microsoft's already talking about, Google is already talking about the next thing is going to blow Bard away and blow GPT away. So, yeah. They do a great job of predicting what the next sentence should be. That's the whole point. That's the whole point of everything AI does is it predicts what pixel should come next to another pixel or what word should come next to another word. That's all it does. It's a prediction engine. And by design, it cannot create anything new. All it can do is combine. By design, it can only combine things that already exist into new ways, into new things, but nothing new in and of itself. From language to image. Let's just stop there. This thing might be dying. They're generators that are programs that apply machine learning to descriptions of massive data sets and images. They allow, and by the way, Kirsten Zergner will help me with this because she knows this way better than I do. Here's what we're going to do. I have no freaking clue. That is literally how it works. That is literally how the algorithm trains data. Okay? That's the diffusion process. I do kind of know how it works, but I don't think I could explain it. And there it is. No, I don't really. This is a better way to think about it. I'm dead serious. This is the best way to think about it. It's what it does, right? We just have this huge stack of data, and we just smush it around until it looks less wrong. And that's literally what they've done. And we've got to a point where most things that the algorithm is smushing out are less wrong than right. Yeah. Through trial and error, the goal is to pair image to text or things like that. Every time the system identifies an image, network weights are adjusted until it gets less wrong. This is a great example. I love this of latent space. If you take a look, does the blue green thing work? Aha. So if you look up here, right, you see a 5 kind of clustered in with the 8s. This is why we get like multiple fingers, because the thing that looks like it should have an extra finger kind of looks like an 8. It's a great example of latent space, of what the algorithm is actually doing when it is smushing things together so that it thinks, all of those 8s are the article the. Okay, so maybe the thing that should come after the word the is night. But that 5 sitting up there is zebra, right? So it's a great example of how things that are similar, the AI algorithm will use to smush together. So when we were just talking about this, we decided not to go any further, right? The acceleration and the development of AI it's ridiculous. We are in that realm of exponential advancement, right? It started years ago. You see how it expands from 2015 to 16 to 18, and the full second half is all 2022. I would need another page just to do the first half of 2023. So this stuff it's not, to answer that question, it's not going anywhere, right? It's not. Speaking of Kirsten Zergnable, so this is her training. So she's created a closed system, right? No one else can access it but her, and she's trained it on her own work. This is what it can spit out with her own work. And it literally is her work. The best analogy that I've heard about it is like having 100 Renaissance apprentices painting for me. So this is what we're talking about when AI can actually help you. It can actually be a boon, a benefit to society when it's your work and it's helping you do your work, right? But what happens when, say, Microsoft has that closed system, right? That's a thing. It's horrific, and it's plagiarism engine time. I think we spent enough time on how it works because that's not really why we're here. Ethical considerations. Here's a fun one. Representation, right? Hey, what happens when I tell it to give me a photorealistic picture of a nurse? Huh. Software engineer. Oh no, all white men with beards? What? Yeah. So, there are unbelievable biases built into this system. Any of these training systems. None of them, I haven't seen any algorithm or any database that is not fraught with these issues. Lawyer, old white men. Flight attendant, oh, Asian woman.
Oh no.
Yeah. Elf warrior, not so bad. Gee, I wonder what it is about orc warriors that might make them all show up as, 94 male. Right? Could be a darker skin. Who knows? So that's the representational side of things. Let's have a little chat about artistic integrity. Show of hands. Yes or no? Raise your hand if it's cheating. All right. How about this one? Yeah. Okay, the goal is a commercial product that you're going to deliver to somebody. You're going to deliver a commercial product to a client.
That's fashion. Right. Right.
Do you mean Photoshop work?
Yeah.
Like a collage?
Yeah.
Did you take the photos yourself?
Right, but here's the point, right? If you took the photos yourself, yeah. Are they Getty images?
No, if you took them yourself, then you're.
It's right.
So that's not cheap.
Okay. The point here is to have this discussion, right?
It depends.
Yeah. All right. Stamp scatter brushes.
Depends on the client.
See? How about tracing?
If it's your own
I
work.
don't know if cheating is a good word for it.
I couldn't think of a better word. So if you guys have a better word, what do you think there's a better word?
Plagiarism?
Okay. But see, that introduces my biases, right?
What I say is,
But-
I said to a client, I'm going to draw your house, I'm going to take it from photo and put it on a piece of paper with projector, and I'm going to do the same thing and give you the projected image, and we'll see whose art is better.
Rather than cheating, when I use the word ethical.
Sure.
Or diminish artistic integrity.
When I found that when I use that word, people don't want to reply because nobody wants to be considered unethical.
So diminishing artistic integrity, maybe.
Okay, limiting your options.
Depends on the origin of the work, though. Like if it's you're tracing your own work, that's different.
That's certainly not right. Right.
Yeah. Or if you're tracing a photograph, a stock image that maybe
That's not your own
you,
work.
yeah, but what if you purchase the rights to it on a website, right? More questions.
I want to hear that statement out loud. Mhm.
I would say that all of these things, to some degree, take away the amount of options you have if things are coming from your brain, but it's every artist's job to curate what decisions get made by their reference and tools versus what
And
comes from
that is a lovely comment. We're going to come back to that comment over and over again. You know why? Because you have literally just described what the Copyright Office has said qualifies for copyright protection.
Yep.
Right? If it has to come from your brain. You as the human being have to make the connections, you have to make the decisions. Literally, that is what there's a slide on this, we'll get to it shortly. But that is exactly what the Copyright Office is saying. Now, we'll get it when we get there. We're going to go down a rabbit hole if we do that now. There are people who believe this is also photography itself. If you can't do it from a model or your brain, or that's the last bit.
I think any and all these can be misappropriated.
Yeah. And they exist to have this conversation. They exist to make us think about what it is we're valuing, how we're doing the work, why we're doing the work, and what is protectable about it and what is going to get you in trouble about it, particularly with a client. Right? This last one up there is the best thing I can tell you if you're going to submit something that is AI assisted to the Copyright Office. They're not saying you can't protect it. They're just saying it's fuzzy, and we'll talk about it more later. But they're saying that there has to be a modicum of human involvement. That's the bottom. Have you taken something without asking? And by the way, what does taking mean? That's the key, by the way. What does taking mean? Did the database itself take all that work that it scraped? Of course it did. But there's a lot of capital allied against the side that says, yes, it's taking. All that capital says, nah, it's fair use, we didn't take it. So,
Don't put it on the internet if you don't want to take it.
how about this one? Like who says 1 is where we should stop? Anybody? So are we kind of all in agreement that we can use AI prompt generation? That's kind of okay. That is a great answer. My answer to this, by the way, is it is the fruit of the poisonous tree. So the second you use it, you are assisting and aiding and abetting. That's a legal term from criminology. Basically, it's literally like you cannot use this evidence because you broke into their house without a search warrant. It's the fruit of the poisonous tree. That entire database is poison. Anything that comes out of it. Right. Oh wait, let me go back. So can we stop it using no artist names and prompts? We can use prompts and whatever. And we go on to, okay, well, let's only use deceased artist names. And then that slippery slope just keeps going. Yeah, you had a question.
How recently deceased are we talking?
That's a good point. Yeah.
Well, what's the European data set that's actually was designed to recreate Renaissance painters? Absolutely. And quite frankly, fine art, when you type in fine art, it's going to show a whole bunch of European paintings. It's not going to show you any Asian paintings. It's not going to show you any, sub-Saharan African paintings. Nope. So, yeah. How about the bot? You'll be a very brave individual indeed, but is there anyone who would either admit to or agree that 7 is where we go? Seth Rutledge does, but.
Your own name.
Yeah, I mean, if it's you, right?
Right.
Sorry, I'm just playing devil's advocate.
Yeah. Plus, he probably didn't choose what's in the data set of
Right.
his work. Like I didn't choose the paintings they scraped, and everything that comes up with my name looks like it was made in 2013, which is most of the work they took from me. It's wild.
Another problem with that is, yeah, it looks like he's getting one over on the companies, but he's also helping them goddamn train the next generation of AI.
Yeah.
Right? Like, come on.
Yeah.
But that's I doubt that's what he's doing. It's not a closed system. Like if he got the database and was allowed to do it, I don't think that's what he's doing. Yeah. Yeah. All right. So look, we're going to talk about the legal stuff now. Chime in whenever anything hits something in the lawsuit. So
Yes.
broadly speaking, here's the two main issues that we want to talk about when we're using machine generated content, right? Intellectual property rights. Okay, who owns it? What rights do you have? What rights does the service retain? Okay, and then the second part is what is the risk, right? What is your legal risk in using this stuff? If you're gonna use it in any way, it's interesting to do this in front of an auditorium of artists because I often do it in front of an auditorium of filmmakers, and they have a much more relaxed attitude toward it, even with all of the SAG-AFTRA stuff that's been going on. And by the way, congratulations to SAG-AFTRA; they're holding strong. We hope it all pans out. But the Writers Guild actually got that their stuff cannot be used. Who thinks the AMPTP is lying and that their scripts are going to be used to train databases anyway?
Yeah.
Right? Like, oh, we didn't do it. It just got scraped somehow. I guarantee you that's going to happen. But they did get it into the Writers Guild contract that they won't do it. All right. This one and the next one. If you are using anything AI in something that you are commercially delivering to a client, you are exposing yourself and your client to unbelievable risk because they can't copyright the thing you're giving them. They will have significant issues even if they can. And you might have put them in a position of lying to the Copyright Office about it. Okay? And how do you protect your own work? The cognitive dissonance destroys me when I see prompt jockeys pissed that people are using their own their prompts to make things that look like their work.
Glorious.
I can't. I turn to Lewis Black. I literally turn into him when I start thinking about that. And you're exposing yourself to a lawsuit, right? Does anyone here, and there is no judgment here, like, does anyone in here find it helpful and use it for things that they're not delivering to clients? Okay. Like, I'll tell you, my wife uses it to generate scripts for content she makes for her business, right? Because she does training videos for a company. And she literally says, all right, I don't have time to write a script about how this piece of software works. ChatGPT, write it for me, I'll edit it. That's a thing, right? It's still the fruit of the poisonous tree, but perhaps a little less than, hey, make me a painting that looks like Harry McCarron's, right?
I think in this context, it's like, what is the profit potential off of it kind of thing? Like it's an internal kind of generator or something like that.
Yeah. What do you use it for? And you don't have to tell us if you don't want to. I mean.
So I write and illustrate children's books.
Okay.
And I use it for sometimes another perspective to create a certain kind of rhythm for certain words, but it's terrible. But I use it, for not that my work is really taken from it at all, but just almost like another perspective.
I've seen writers use it to relatively decent effect to say, write me this paragraph, but written from someone who lives in Nairobi, Africa's perspective, right? Like, I'm checking the white bias of my work, and I've seen it used like that. I mean, again, through the poisonous tree, but at least the end goal is a noble goal, right? You're trying to make sure that you're not just, the great white savior writing this book.
And there's arguments of that you're taking away possible, like, an actual person's input instead of what
Right.
the algorithm decides is that person's
Yeah. There are certain companies that have probably put out insensitive products that could have perhaps benefited from hiring someone of that culture to look at their product. Yes. Everybody familiar with this one?
That's how I feel.
So this was one of the first known copyrights, and so they really didn't tell the Copyright Office that they used it, and the Copyright Office, once they found out, revoked the copyright. Said you can have a copyright on the stuff that was human created, but you can't have a copyright on the stuff that was machine created. All right.
Yeah, they basically this artist built the whole thing on Zendaya's likeness, by the way, and barely changed the name. And then the Copyright Office was like, "You can keep the words you picked. That's it." And yeah, it's hysterical.
It really is. Here's Getty bans copyright work, and then of course they sued. Here's the lawsuit. Here are the images with the Getty logo showing up. Yeah, right. No. Getty's database wasn't trolled wasn't scraped for the database. No, not at all.
Draw football player from memory.
Yeah.
Basically.
Yeah.
Oh my gosh.
So it has been trained, and we'll show this with Kelly's slides, that the database has been trained with so much Getty watermarked work that it thinks the Getty watermark belongs in these images. Okay. You ready for the thing that I said earlier when I said really?
Called it.
Commercially safe generative AI. Really? Commercially safe? Yeah? So Getty Images literally said, no, we're not going to accept any AI because we're making our own AI product. And it's going to be, if you have ever put an image on Getty, they're saying that what you agreed to when you put your image for sale on Getty was to allow us to train our database with it. Yeah.
So I'm actually curious, because like you know more about the contract probably, but like, do they buy like, I guess it's a matter of like what rights they bought when you
So here's a fun one. I submit to you someday, go look at any website you ever visit's terms of service, right? And there's a clause in there that says, we can update this anytime we feel like it, and it's your responsibility to check back every time you visit our website.
Wasn't there an opposite one where it was just like no one actually reads these lists, so like they're not binding, or am I making that up?
No, you're making that up. Yeah. Yeah.
Nice, nice try.
Yeah, it's the way capitalism bad. I mean, every issue that I deal with as an attorney, for the most part, is an issue of, at its base, capitalism. Like which company's screwing which other company and how to not get them screwed. My client, that is, right? When did they do this? Do you remember?
Oh, very recently.
Was it like September 24th? There it is.
24th, yeah, because they announced their lawsuit the day after we announced ours.
Oh.
Which was hilarious. And it was just like, y'all, I don't think this is gonna go the way you want it to. And yeah, they were just making their own. They were just trying to protect. Yeah. Knew it.
At the end of the day,
You don't join them?
at the end of the day, all roads lead to porn. But let's think about this for a second, right?
Oh my God.
Let's talk about AI influencers, right? AI generated, but she's got like almost 1 million followers. I did this when she had like 500,000 or something, right? Right? What happens then? What if we swap out her? And this is happening all day, every day.
Yeah.
There are apps now that will do that for you. It is one of the biggest websites. I'm not going to name it here, but it exists to do celebrity porn, AI celebrity porn. They've been working on this for years, and I mean, I have clients in the adult industry. I have one client who does not own her virtual vagina. There are 9 women sitting in a room VRing her all day, every day.
Oh my god.
She has licensed her body. They put her in mocap, right? And now they don't even really need her to do any vocalization because the AI is doing the words. They don't even need the people that were behind the AI generated model. Who owns the IP of this, right? What happens if somebody wants to hire this influencer for their product? Right? It's fraud if Claudia, spelled like in leet speak, that's literally her name. The entity hiring Claudia would need to know that they're not actually hiring a person, right? It's literally a white guy from LA. Yeah. They don't have any IP rights in Claudia because Claudia is all AI generated. So it's all the company who's basically said, we'll go through the terms and conditions, by the way, of OpenAI and a couple others later, and you'll laugh your ass off and then cry. If somebody tries to hire this influencer, they're going to expose themselves to obscene amounts of risk. And there are companies out there that just have algorithms that hire influencers. There's no human looking at it. Yeah.
This may be a very silly question.
Sure.
It is still illegal to own a person, right?
Yes. Well, ever since the Emancipation Proclamation, but before that, it wasn't.
To own a person's likeness is different, right?
You can actually.
That's the distinction I'm
Right. So you can license your likeness away, which is what a lot of people do. Right? That's what my client did in the adult industry. She licensed it away. She got paid a chunk of money for it. Revenge porn. What's that?
So is she suing to get her?
No, she got paid a bunch of money, and she's like, I signed the license. I knew what I was signing.
Oh, okay.
Yeah.
I was curious.
5 days from the commercial launch. Right? 5 days from the commercial launch of what was it? OpenAI, whatever, one of the two. Started in the 80s, obviously. 1 in 25 Americans. I did not know this. So, like this slide I updated, like I didn't know that. We don't have numbers for 22 or 23. Actually, we do. This is from Thursday. Right? This is literally, I added this slide Thursday afternoon. And first 9 months of this year, 113,000 videos were uploaded to the websites, 54% increase, right? By the end of the year, the analysis forecasts more videos have been produced in 2023 than the total number of every year ever. The internet and AI apparently is for porn.
I think
So.
that brings up the interesting concept too of
Mhm.
and the bias in the porn industry for younger, prettier, more risque,
Yep.
inappropriate.
We know where that's going.
Is that gonna feed into that?
Of course it
Yeah,
is.
propagate
Of course.
unrealistic.
Yeah. Where are we? Oh, all right. So let's move on, and we'll talk about the. Did somebody have a question? Or was that outside? That was outside. All right. Okay. The photography comparison, right? Everybody wants to say, oh, well, hey, AI and photography. When photography was invented, people thought, oh, it's going to destroy artists' lives, and they gave protection to photographers. It's just the same with AI. It's just a different way. It's not. All right. This law goes back to '84. Right. Supreme Court upheld the power of Congress to extend copyright over photography. And the defendant argued that the photo of the work of a machine was not a creative expression. Court ruled it is a representation of the original intellectual conceptions of the author. This is what we're relying on for 150 years now. This is what we should be relying on. It's right in your case. It is literally there is no original artistic conception of an author. There is an art direction, maybe, and that's even pushing it a little bit, right? The control that basically this court said the control he exercised over the subject matter, right, showed that he was the author of the original work, and thus within the class of things the Constitution grants copyright protection. Who owns the IP? Right? That top is here. Mid-Journey terms and service. You own all assets you create the services, yet it's subject to a major caveat. Guess what you give to Mid-Journey? So anything. If you ever upload any client language, if they sent you a press release and you want to perfect it in ChatGPT, or sorry, you've just you've literally given another company the intellectual property of your client if you load that press release up. If the client gives you reference photos, you have violated their intellectual property rights because you've given a license to Midjourney by uploading that, saying, give me an image that looks like this, right? This is a repeating refrain. We'll hear it over and over again today. The terms of service of these companies absolve them from any risk and shift all of the risk onto you. That's in the legal, we call that risk shifting. And it is my job as your attorney to shift all the risk onto the other side in a contract, just like it is their job to shift all the risk onto the users in these terms of service. Okay? This is a blast. We're going to love this one.
This destroyed me.
Okay, you can't use services in a way that infringes, misappropriates, or violates any person's rights. No one would ever use OpenAI in a way that would infringe someone. No, you would never do that. Never say, give me a photorealistic photo of Darth Vader. You would never do that, right? Or Billie Eilish, right? So violations galore. All day, every day, no one on the OpenAI side is looking at this. They don't give a shit. They pay lip service to it, but no one is following this on the other side. Can't use the output to develop a competing database model. You can't use the output to develop your own AI. You can't represent that the output developed from these services was human generated when it is not. That's a change. It did not used to be in there. That happened right after this Zerai of the Dawn bullshit. So they changed their terms of service. So you are not only are you in violation of OpenAI's terms of service, but you're in violation of the copyright if you lie to the Copyright Office and say this is mine. Responses that are requested by and generated for other users are not considered your content. How many times do you think it is spit out the same painting? How many times do you think it's spit out? Literally the exact, probably thousands for everything, right? So what happens when you go to try to copyright that? And it's generated 1,000 times for different people. We do not, where is it? Use of the content to improve our services. We do. This is new, and I'll explain why it doesn't matter. We do not use the content that you provide or receive from our API to develop or improve our services. We may use content from services other than our API. Unless you are licensing their model for thousands of dollars, hundreds of thousands of dollars, if you're just using the commercially available version, that doesn't apply to you. Of course they're using your data. You have to buy the API and integrate it into your own product before they'll not use your data. Okay? If you do not want your non-API content used to improve services, you can opt out. It doesn't work. If you actually try to opt out, you can't use the service. Yeah. Please note that in some cases, it literally won't work if you try to opt out. Yeah. Accuracy. Hey, this is rapidly growing and evolving field of study. We're constantly working to improve our services, make them more accurate, reliable, and beneficial. Given the probabilistic nature of machine learning, use of our services may, in some situations, result in incorrect output that does not accurately reflect real people, places, or facts. Basically, this is saying, yeah, when it tells you that Q said the election was stolen, we're not responsible if you go kill a bunch of people. Like, literally, this is saying it may not be factual, may not be right, it may not do anything for you. Risk shifting. Here's the one that made your head explode. I'm not going to make you read the whole thing. Just read the stuff highlighted in red. Right? Our aggregate liability under these terms of service shall not exceed the greater of the amount you paid for the service that gave rise to the claim during the 12 months prior, or the liability arose, or $100. Sorry. So unless you're paying them for money, the most they'll ever be liable for is $100. Yeah. Right? Here's why this matters. So somebody comes up and says, hey, you delivered something using AI, and I'm either harmed by it or I got sued because of something you delivered. They're going to name OpenAI in the lawsuit as well. That language means you're paying for OpenAI's lawsuit. You're going to indemnify them. You got to pay their lawyers for something that they got sued for because you used their product to make something. You are paying for Microsoft's lawyers because you used their product. Okay? This is why we contract lawyers like to read things, right? My wife wanted to kill me when I read the closing documents for 4 hours at our closing on the house. Right, and by the way, if somehow, some way, right, that they're found liable, okay, here's your $100. $100 cash money.
Why would they even fight it at all if all they had to give them $100 to done with it?
Well, because they got to defend the lawsuit. They're going to get named in the suit. Yeah. Here is where where I'm at as an attorney, as a creator. Are they all derivative works? Is everything that it spits out a derivative work? Because it cannot, by its very nature, make something that didn't already exist because it had to scrape and learn, right? And by the way, that word learn, I hate that word. It's not learn in the human sense. And everybody says, oh, I can go into a museum and look at 5 paintings and then paint something that looks like that. That's just what the machine's doing. No, it's fucking not. AI poses a massive competitive threat, right? To anyone who's a creator. It's a massive competitive. If you haven't thought about it in that terms in the business world, that's what we call it. AI is a competitive threat to you in the business place. Seems that the use of existing copyrighted materials isn't. It is. It doesn't seem like it is. It's integral. You cannot have the database, right, without using all the pre-existing IP. The argument seems reasonable, right? That it is all the fruit of the poisonous tree. Everything's a derivative work. Particularly when it spits out something that has Kelly McCarran's signature at the bottom of it.
Yes. We're going to show that.
Yep. So the Copyright Act broadly defines derivative work as a work based upon one or more pre-existing works in a form in which that work may be recast, transformed, or adapted. Sure sounds like that's what's happening. Like, that's literally the Copyright Act. That sure sounds like exactly what's happening with AI. So work is the thing, the thing, the creation. I'm sorry, can you say that again?
So are they defining it just as a product in general,
product in general, anything that is a thing. Major fictional characters like Pikachu, Mickey Mouse, right? All these things generate images when you start going in. They're not supposed to be able to, right? They've said they've implemented all these safeguards and done all these other things, but at the end of the day, Pikachu standing in a puddle of blood, murders Pikachu. Sorry. So when I go into Midjourney in my Discord and I type in murders Pikachu standing in a puddle of blood, that's what I get. Okay? I mean, what do you think the Pokemon Company has to say about this image existing in the world, right? What happens when Disney, Warner, or Universal start getting involved in this stuff? Now, I'm getting a little more concerned because of Secret War, like basically what they did with the AI for the intro segment in the Samuel L. Jackson miniseries, but
Secret Invasion.
Secret Invasion, thank you. Secret War, that was a different thing. Beyonder. Anyway, I'll shut up now. I'm old. Yeah, training the database. So look, if an AI provider used a database of publicly available copyrighted materials as the source material for the project, right? Like, look, that's how it works, right? There's the argument that the entire data set is tainted by the unauthorized copyright infringement. They're crucial to the process of AI creation, right? The AI cannot do what it does. And if they were used without a license and reproduced or adapted without consent, then, hey, look, that's a breach of the rights of the holders of those copyrights. And I think that's pretty much the basis of the lawsuit, right? What do you got to do? What do you got to do to make something copyrightable? Look, the only thing we really care about here is this, right? Developed, perceived, reproduced, or otherwise communicated directly. Oh, wait, sorry. No, that's not what I wanted to see. We're going to talk about the human thing, right? But in no case does copyright protection for an original work of authorship extend to an idea. Okay, that's another thing that they're trying to claim, right? Like they're trying to claim protection over this idea. That's the prompt jockey argument, right? They're like, my idea for this painting is the thing that's copyrightable. If I can't copyright the thing because the Copyright Office said no, they want to make their text that they put into the prompt which is just nutty. In non-lawyer speak, it has to be an original work of authorship. You can't protect a bare idea, right? It requires human authorship, but the statutes themselves don't really define what an author is. And we have to look actually to the Copyright Office Compendium of Practices, which actually say it protects fruits of intellectual labor that are founded in the creative powers of the mind. Okay? And again, this is 1879. We have been doing it like this for 150 years, and of course, Microsoft says, well, that's wrong. Yeah.
Poetry is copyrightable, right?
Mm-hmm.
And coding, which is kind of considered a subset of
Software is
poetry,
absolutely copyrightable.
is copyrightable. So is there a length of a poem or a length of code that makes it copyrightable? Is there a certain
No, if I write a book of haiku, I could absolutely copyright every one of those haikus, and they're tiny.
Interesting. So the code jockeys that want to copyright their data entry into AI,
Mm-hmm.
how does that differ?
Modicum of creativity.
There it is. Yep.
Right?
I'm playing devil's advocate here.
No, that's fine. That's great. These are the things we should be talking about, okay?
It's the same concept in software too. If there are patterns that aren't copyrighted, because everyone uses
Well, and that's another one of the lawsuits against AI, the GitHub Copilot lawsuit.
And it's our same lawyers, actually. So that lawsuit is helping our lawyers determine the steps to take with the lawsuit with the artists, and also they're representing Sarah Silverman and a bunch of authors as well. So these three lawsuits are all connected, and the GitHub Copilot lawsuit is going to help us navigate the next two based.
GitHub Copilot is this for code.
Right.
Yeah.
So there's basically it's a repository of snippets of code, right? And most of it is Creative Commons, but the AI database isn't properly, attributing. It isn't doing what it's supposed to do, and people are seeing their code show up everywhere. It's like I wrote that code, and by the way, I'm supposed to be attributed to it, but the AI isn't able to do that.
I'm looking up these. I want to read more about
GitHub
these things
hosts
you're
public
mentioning.
code, but you can license your code on
Right.
GitHub. Public does not mean open
Yeah, and the other thing
Same.
we talked about this a little earlier too in the other class, Creative Commons, okay? When someone says it's a Creative Commons license, I can do what I want with it, there's like 5 different versions of the Creative Commons license. And it literally is a license. You have responsibilities under those licenses. You often have to give attribution. You often cannot use it commercially. There are things you have to do. So be careful when somebody's talking about the Creative Commons license. Okay.
Has AI infringed on patent or trademark at all yet? I mean, those are.
Well, trademark and copyright, it's what patents are going to be a little more difficult, but eventually we will have. If Microsoft has its way, you know, they won't ever have to pay a scientist again because the AI will write all their patents for them. But I mean, the whole point of this is capitalism bad, getting everybody out of the picture except for the tech company to capture all of the money. That is the whole point of AI right now for these companies. It disgusts me. Like, I hate Elon Musk with a passion, but he actually did leave at the right time. When OpenAI was formed, it was a nonprofit. And as a nonprofit, it got access to databases that only nonprofits get access to. Guess what happened when they took a whole bunch of Microsoft money? They turned into a public corporation. Oh, but we already have all that data. Sorry. It's horrific. So
The database that all of our art, most of us probably, is in the Lion 5B database. That's the 5 billion text to image data pairings. That was made as an open source nonprofit project, but it was then under the OpenAI thing before they changed to
commercial entities were never supposed to have access to that database.
And yet.
So there are situations where a human being and a machine do work together, right? Copyright law isn't biased when it comes to the tools we use. This is the scatterbrush stuff that we were talking about earlier, right? We do award copyright protection for photographers, right? They might not be creating a even if they are capturing a wholly natural scene, the modicum of human creativity, they're choosing the time of day, the angle, the color of the light, the composition, the angles, the position, everything, right? Courts have found that photographers' choices in how the scene is photographed suffice. But again, this is the argument, that last bit that the code jockeys that the prompt jockeys are making too. Oh, well, that's the modicum of creativity, our choices. So, I don't agree with that argument, but it is relatively valid. Vampire Brat wearing a sombrero, right? So when I tell the machine to make that, do I deserve the copyright for that? Right? All I did was supply the bare idea and rendered it into text. The machine did the rest. And as we know from the statute, right, an idea cannot be copyrighted. And this is what a lot of everything's resting on. That. Bad art directors, maybe, but we're all, right? My creativity was evolved in an uncopyrightable idea, right? Not in generating the expression of that idea. But I did select the image above, that one in the sombrero, over several less good outputs. Did my creativity say that, I deserve that copyright on that vampire bat wearing a sombrero because I selected and put in the code? I don't think it does. But the best analogy is that, yes, we are all becoming, it's just like commissioning art, right? I will talk to the artist and say what I want, and the artist will create it and show me some sketches and thumbnails, whatever, and eventually we'll come to an agreement about what the artist is going to create. We, the prompt jockeys, are the art directors. We are not the creators. And that's what I think both the lawsuit and Congress needs to understand, at least. So using AI is similar. You supply the idea, right?
The machine should get the copyright.
That's a great no. By the way, China's already done that.
Really?
Yeah, there's a company in Shenzhen that literally is giving copyright protection to AI-generated news articles and books. Yeah. Well, China's always going to do stupid things.
Well, they mess up.
Yeah. All right. So legal issues in one slide. Here it is. Right. Use of the copyrighted works of source material for the creation of new artworks without the consent or compensation. That's literally what's happening here. Right. Potentially all of these are derivative works. Potentially anything you do using AI is a derivative work. Right. Infringement of trademark and other IP rights. Right. By permitting the unlimited generation of images of persons, brand names, logos. I can do Pikachu. I can do whatever. It doesn't matter if OpenAI has in their terms of service, you can't use our service to do this. It still does that, right? So, if Disney got it into their head, that'd be a fun one. I would love to see that. I would pay cash money to see Disney and Microsoft go head to head on this.
I just keep hoping that might happen. I feel like they're waiting to see what happens with our lawsuits before they do anything.
I agree. The creation of the algorithms, right, and the image databases are based on copyright infringement. That's the whole argument. The training algorithm includes scores of copyrighted images, everything. And these companies are, by the way, facilitating. So even though their terms of service say you can't do it with our service, the service still allows you to do that. They are literally complicit in it. So. And there's that bottom one. Right? There's new Copyright Office guidance that came out in March of this year, right? And it basically says, case-by-case basis, we're going to let you know on a case-by-case basis. There's no hard-line distinction, unfortunately. They and I. Here's if you're going to do anything with AI and you're going to submit something, here's the big one. Never lie, even if by omission. And I'll talk about this when Kirsten and I did one for a game she created, and she was very clear. Here's what I used AI for. Here is what I did. And I mean, it's significant, right? It's, I changed the color of 20 things. I moved them around. I did, right? But don't lie. Make it very clear. And even if you don't get protection for the AI generated portion, you will get protection for the text that you wrote and the images that you created, which means it would be functionally impossible for someone to rip that off because they'd have to take the stuff you did get copywritten in addition to the stuff you didn't.
And you do that when you're getting it registered.
Yeah. Yeah, absolutely. I would, if it ever comes to light, like if there's a watermark in there somewhere that you don't know about, like it wouldn't surprise me to find out that everything from a digital standpoint or a pixel standpoint or something, there's a watermark in there somewhere so that OpenAI or Midjourney, that they could identify their own. They'll never admit it publicly.
They were supposed to do that actually.
Yeah.
Initially, yeah. So like one of the earlier versions, there was a watermark like within the metadata that would identify it as AI generated, and they got rid of that.
No, because it's expensive.
Right. Well, right. So they were just like, we're just gonna get rid of that problem.
Yup.
I have two questions, different topics.
Okay.
How do we follow your case? I'd love to follow along with the progression of these various cases.
Follow her on all of her social media.
Yeah, me, Carla Ortiz. Sarah's not too active, but me and Carla are like pretty on top of like what's going on there. Follow the Concept Art Association as well. They're doing a lot of work with Congress, like a lot of amazing work.
There's another thing everyone in this room could do, and we'll talk about it at the end.
Yes.
Actually, here. Call for comments. It's the next slide. It was originally, so the Copyright Office is literally saying, anyone who has a dog in this hunt, please submit a comment.
Yep.
If you take a card, I will email you a PDF that you can upload to their website. I'm dead serious. And what is, I actually used the stuff from...
It's Luddite.pro.
Luddite.pro. If you want to just go find it, Luddite.pro.
Yeah.
He's got it. Because literally, it's a 29-page document. It would have taken me 2 work days to create it from scratch. And I just don't have that time right now. So I literally just caught myself doing the thing I did when I was 12 years old, looking for something around the room that would hurt but not kill my little brother to throw at him. Literally.
Your shoe.
Something.
There's a couple cans.
This shoe might kill him. But no, seriously. So, I'm not, like, I don't. It was just funny.
Social media platforms are you on?
Twitter mostly. Instagram.
What's the handle?
Her name?
Kelly McKernan. KELLY_McKernan. MCKERNN. I can give you a card later.
That'd be good, 'cause I can't spell with the damn.
Yep.
No
And
worries.
you had a question?
So call for comment. Is that something they're just like we got? So how do they like quantify that data, or how do they like put that data so it's like we got this comment that was vaguely for, vaguely against. Let's do those.
Yeah.
more
So
comparisons.
if you want to,
Yeah, I was just gonna say, so if you go to the website, they give you, you can just write whatever you want, or they give you like many questions, very specific
there's like
questions.
40 questions.
Yeah, that you can reference and answer as many or as few as you want. So you can specifically respond to their questions if you want to.
Go to
It's
go to
pretty
Luddite Pro
straightforward.
and down
Yeah.
and just like if you want to just copy and paste from that website. That's what my PDF is built from, and you can just. But you have to say this is in response to this question. This is in response to that. If you're going to do that way, otherwise you can just put up a general comment.
That's what I did. I did a general comment, but yeah, you can also respond to each individual question if you want.
And I have friends who work for the PTO and the trademark and the copyright office. Like we live in DC. Like I just know people because of where I went to law school and where I live. And there are human beings, not AI, not an algorithm. Every one of these comments will be read by a human being that works at the copyright office to generate, we've got an outpouring of hundreds of thousands of people who are worried about this for these reasons. And that's why I encourage every single one of you to please make a comment.
This is our opportunity right now.
This is you as a United States citizen. Literally, your government is asking you, what do you think about this? Right? Congress is not going to, they're going to take their sweet old time. They're not going to do it right. This is an agency that has direct authorization to fix a lot of this. And you can be guaranteed someone will actually read. Like, no congressman's ever going to read your letter to him. But someone human there will. So have we beat that dog enough?
Yeah, do it, please, do it.
Is it extended to October?
Yes.
It has, right.
Do you think that it will be extended again?
I don't. It's been extended twice already, so
This is true. Yeah,
I
it's
would
fine.
get your comments in as quickly as you can. But you have a couple of days. They have at least a week right now. Where are we? 21st, yeah. I get this question all the time. Can an art style be copyrighted in the U.S.? No. In the U.S., we cannot do art styles. That is not the law in certain European countries, by the way. So you can actually infringe someone's artistic style. I don't know. I'm going to call on I don't know about, is that the case in Belgium? Do you have any idea? Okay. Of course there are. It's crushing, I know. It's,
Yeah, it's heartbreaking.
oh, hooray. Welcome to late stage capitalism, dear.
When I found out that over 50 of my paintings were scraped, and I was able to, we have a slide, but of every piece, my relationship with every single one of those paintings has changed. Every one of them.
Yeah.
And devastating. I didn't paint for months.
Oh, man.
Yeah, for like 3 months, couldn't paint. It was awful.
So again, this is international stuff. I want to get to those slides.
Yes,
Yeah.
yes.
So that's that bottom slide in Shenzhen. They've given copyright protection. Of course it is. Who do you think it would be? Yeah. Here's one. So we're gonna start talking about lawsuits galore here about AI. What's this one from? I gotta look at the date. So we're starting in July on this one. Okay. Yeah, Google has secretly been stealing everything ever created and shared on the internet. If you think they are not, how do you think it sorts your inbox? How do you think your Google inbox gets sorted? Right? Like, so, yeah. This one is OpenAI, right? This is San Francisco federal court, privacy laws. Complaint filed on behalf of 2 unnamed software engineers who use ChatGPT. Accuses the software. This might actually be the other case.
I think this, yeah.
And this is from September.
That's us.
This is you. There's your. Wait, where is it? There you go. Named in the lawsuit. You get. I'm not actually even named in a lawsuit. No. Like I said earlier, if I'm ever in a courtroom, I am the defendant. So, do you want to talk about this before we move on, or is there anything you want to say about progress? About
Yeah, so I can give you guys a little update. So we haven't had any movement in about 2 months, but we had our first hearing back in July, and we were basically presenting everything to the judge, William Orrick, something like there's like a 3 after it. I don't know. And from what I'm hearing from our lawyers, is that they are pleased with our assignment of the judge.
get half your face.
Oh, here, have my whole face. We're pleased with him. He seems to really do his due diligence. With that said, the hearing, there were some articles coming out that were saying like, uh-oh, this looks bad because the judge had concerns and questions about our lawsuit. So what really happened was him laying out very clearly what he needed clarified. And he hasn't yet given us the go-ahead to amend our complaint, in which case we're going to go into like the next probably.
You are going to amend the complaint.
We are, which will be a very good opportunity to bring in new artists. And
Iris.
there are people here at the show this weekend who are also involved, not publicly yet.
Sorry, I didn't mean to call you out, by the way, if you are not, like...
Yeah. Anyway, so he hasn't responded officially. It's been 2 months. They're, like, expecting it to happen any day now. But we have gotten the go-ahead to enter the discovery phase with Stability. So we get to basically interrogate them, and they have to respond to us with stuff. I'm very excited about that. What else is going on with that? Yeah, so it's just going to be probably a years-long situation.
I have a question. Has anyone in here been to Have I Been Trained and found their work there? Can I show hands? Cynthia, have you gone yet?
I didn't know that was a thing.
You should go to the website Have I Been Trained and see if your artwork is in the database.
We're gonna find out. You can search your name. You can search by image. Yeah.
I don't paint birds like that. So I encourage all of you to go in there, take a look, and see if your artwork has shown up in one of the training data sets. I think so.
There's, yeah.
Are you in there?
Yeah.
So I would not surprise me to find everyone in this room who has ever posted a piece of art on the internet is in that database.
And it might not even be attached to your name. I have a good chunk of my work doesn't even have my name attached to it because people just uploaded it to Pinterest, and Pinterest is scraped wildly.
Social media is scraped all day, every day. So, just last week, by the way, this is a huge thing. It doesn't seem like it is, but it is for privacy reasons. LinkedIn just changed to you cannot access anything on LinkedIn unless you have a username and a password and are logged in, which means they can't be scraped by anyone looking for public information. You can still look at Facebook and Twitter stuff if you're not logged in, but once they change, that's a huge deal for all of these plagiarism engines. What's that?
It doesn't stop them. They're hiring people on the other side of the world to go through manually.
Yeah, let them I can't imagine the money that. I guess they certainly have the money to spend. Oh God.
I'm not surprised.
Capitalism bad. That's awful.
Do you see anybody following suit on that policy?
I think Facebook Meta's going to do it because they want to own all the IP. They want their own. They're making their own training set. Right. So they'll do it, but not for the right reason.
Right. Is that the answer to your question? Yes.
I'm sure.
But the first entry is actually a picture of my face
Oh my God.
from the 4 minutes I had a cooking vlog.
That's amazing.
And wow.
Yeah. So you're all going to be in it. I encourage you all to have lovely sidebar discussions with Kelly and perhaps think about joining the suit.
If you have registered copyright and you have work in these databases, get in touch.
Yeah. I think this is also your attorneys?
Yeah, this is us.
Right? So this is Sarah Silverman. Is George R. R. Martin in this one? Or is that him? Is he doing his own separately?
That's another one. I think it's another one.
Got it. But again, right? And this, by the way, note the date. So the date on this one is September 12th, right? Authors sue Meta, OpenAI. OpenAI is owned by Microsoft. Microsoft offers legal protection for AI copyright infringement challenges. That's just a couple of days before they were sued. Right? I love that. Firefly AI. So that was launched last month. Is it the next slide? It is the next slide.
Yes.
Hey, look at that. August 17th. Why hasn't Adobe banned it? And I think that the day I posted that was like a Thursday a month later.
Yeah, so I should clarify the signatures have nothing to do with Adobe, but I was able to find that, okay, that top left is an AI generated version of my signature. The next three images are my signature to compare. And I only found it in one image, but
Yeah, but still, it doesn't matter. One image.
I cannot believe. So yeah, basically somebody put in a Kelly McKernan painting, and it generated an image with my signature in the corner.
Yeah.
Absolutely infuriating.
Does Adobe take stuff from stored on the Creative Cloud, and can they scrape that daily because it's stored on their cloud servers?
Generally, no, but we know that they already did.
Yes, we do.
Yeah. And this, by the way, was Thursday night as well. And I love how they're painting it. This is a Wired article. Since the federal government has failed to act, New York is actually they're creating a new agency in the state of New York to talk about AI and AI uses, particularly with regard to representation and discrimination. There's also, I didn't put the slide up, but the New York State Film Commission, because everything in the United States is filmed in New York, Georgia, or California. One of the biggest things involved in filming something on location is the tax write-offs you get for having your production in that state. If you give any jobs on your production in New York State and anything on your production that could be done by a human is done by AI, you lose the ability to get your tax breaks.
Really?
Yeah, New York State has basically said, we want you to hire people, not use AI. And if we ever find out that you've used AI for scripts, for anything that a human being could do for you, you lose your tax write-off. And of course, all the prompt jockeys are like, yeah, we just won't film in New York anymore. Right. Sorry, did you want the Empire State Building? Did you want New York City to be a location in your film? Okay. So, I'm giving this presentation in a week in Italy and at the Lucca convention, Comics and Games, and Italy for a while shut off AI. Like, no, can't use it. They just shut it off, and they turned it back on. But I think OpenAI lied to them. I guarantee you, OpenAI lied to how they're actually using data. Wrap up. Look, this is huge. This is like cars. This is like electric cars. This is like trains. It is changing everything. Okay. How the law responds to this stuff is super important. Like, this is why your lawsuit's important. This is why I encourage you not to settle. I know you may end up doing it. Okay.
We talked about it, but it's not gonna happen.
But that's what I'm afraid of, because what I'm afraid of happening for you all is what happened to music artists when streaming happened. I have friends who get played thousands of times a month on Spotify and get like $1.50. It's horrific, and I don't want that to happen to you. Like, you'll get lip service to, yes, we're paying the artist because we know that they were in the database, and you'll get like $1 check.
A lot of music artists had a hard time with their career after taking the settlement.
Yeah. But again, it wasn't the artists. It was Sony, MCI. It was basically all the big companies that owned those artists said, yeah, okay, fine. Yeah. Yep. There's everything here is fraud. If you only take one thing away from today, it's that if you're going to use AI, be really careful about delivering something to a client. You cannot give them what the contract requires if you use AI. There's no way you can. So you're going to have to lie about it, and that opens another whole can of worms. And that is it. That is I did not want to put your email or phone or anything up there, so.
You're good.
My office is in my home, so my phone number is pretty much it is what it is. Yeah. I don't know. I can't speak for Kelly, but I'll answer questions
Yeah, I'm
about
happy
this
to
shit for
answer
like the
any
next 3 hours. So,
Yeah.
or if you, by the way, if you have a drink, then you can come up to me and offer me a drink. No, if you see me at the showcase and you have a question, please, by all means. So,
I accept drinks.
yeah, you had a question, yes.
I'm a little curious because we as artists tend to think of this mostly about art generation on the end, but can you speak to manipulation of source material at the beginning of the process? Say I hire a model and I can't find somebody to look exactly the way I want for this image that I'm thinking of, and I go into a program that allows me to manipulate the face or body structure or whatever to be closer to the source that I want, but then I create a painting that's totally free-handed, traditional.
I would not worry about that in any way. The problem is though, by using the AI, you're indirectly supporting the shittiness, right?
You also can't rely on anything AI generated to even be reliably created enough. Like the lighting is inconsistent. You know, they fixed the finger problem, but you know, I just don't.
There should be a little bit of like any kind of service that's providing AI will automatically be potentially like you should not be submitting anything.
Right. If you upload anything as a reference, that's it. Like that's in the database now. You lost all IP protection on it.
It is progressing towards like being more accessible to have your own offline machine learning model that you can interact with.
The other thing people don't think about when they use AI, just for the limited purpose that you were talking about, what happens if you really like the facial features of what it spit out? Turns out that this person is super famous in China, or this person is super famous in the European Union, and you've literally just created a painting of someone that is infringing, right? Like, I'm just waiting. Like one of these AI influencers is gonna eventually be generated that looks just like a real human being, and that human being is gonna be really angry about it and file a lawsuit for name, likeness, and image, theft.
Is there a possibility of like generating something that isn't a real person, but then you end up making a real person by like doing what feels more natural to?
I have no idea what that means.
Like if it generates some combination of two people, and your artistic direction pushes it more towards one of the two, it might more resemble an actual person.
Okay, yeah. I mean, it's the same problem, though, right? It's the
I think there's that possibility that you can never really be sure that.
Right. What if my new porn AI just looks at Cynthia Shepard's on Have I Been Trained and pops out with her face? Like, there's a lawsuit right there, like literally, right?
Right. Yeah.
I'm surprised Wizards isn't like up in arms because all of their IP is in those databases. You're being recorded, so speak as you can.
No, I would have to give all of my own disclaimers. I do not currently work for Wizards of the Coast. I used to, so I cannot speak to their current stuff. But
I can't imagine. I talked to Don Myrn about it, and she doesn't. She can't or talk to me about it either. But the thing I got was that look, don't fuck with their business model because the business model works. Don't rock the boat. Don't. And I think that's probably where they are. I can't say for sure. So, question, yeah.
So I read an article about the author, this was in writing, who discovered that AI was being used to create books, and their name was attached to the books.
Yeah.
Sold on Amazon.
Yep.
Oh, the Amazon thing's horrific. Yeah.
They were told that there was nothing that they could do about it because their name wasn't trademarked. So I'm not
That's not the real answer. Like the real reason they can't do anything about it is because Amazon won't do anything about it. At the end of the day, nobody at Amazon. Oh, all right.
Here we go.
So this documentary came out 2 days ago. If you haven't heard about it, if you haven't heard about this, it is a BBC documentary. It aired on BBC4 like 2 days ago, and it was a dude who joined Amazon. He got found out after a couple of days as this filmmaker, But the premise of the film is he found out the routes that the drivers would go on, and we all know that they don't get to take pee breaks. He was collecting them, and it was shockingly easy to offer bottles of urine collected from Amazon drivers for sale on Amazon. Shockingly easy to get those things up for sale on Amazon. And that's what the documentary is about. Like, I highly, if you can find it, I'll know what I'll look it up, but it literally aired like 2 days ago. Like, Amazon, nobody looks at anything on Amazon. So if an AI is writing books under your name, somebody's just got a bot somewhere that's writing AI books and submitting them 20 a day. Yeah. Right.
And then that brings me to another question. Since now it's beginning to show evidence that it's generating your actual signature, does that start to enter into the realm of
Fraud?
yeah.
Well,
So, yeah, I mean, you can speak
No,
more
you
on
do,
this,
go.
but like so I've been likening this to identity theft. They've taken my name, they've taken my work, and as far as I'm concerned, I am my work. My work is me. My name, like all this stuff, and it's like, what do I have at the end of the day except for my name and what I've produced with my whole life? So it feels like identity theft. But there are voice actors who are very much saying exactly the same thing. There are writers saying the same thing. There are actors who are like wanting, the AMPTP wants to scan them and use their likeness. It's all Black Mirror episodes. But so part of the lawsuit has to do with right of publicity, and some states protect that and some don't. It's weird, but that is a part of our lawsuit. Is your name is brand, name recognition, and name being used without my consent or compensation. That's all a part of it.
And one of the other things I have to just keep hitting home on is, if you are a creative working in any creative industry, become an LLC, copyright your name, trademark your brand, just do all those things, because it gives more credence to the argument that, because everything in the United States, right? Capitalism bad, everything in the United States is built on use in commerce. Literally, if I go to file a trademark for you or copyright, and I can't show that thing is being used in commerce, they will not give me the mark. I have to show use in commerce. That's the only way I can get something filed at the trademark office or the copyright office. Use in commerce. So please do that. Yeah.
What's what if they use, I'm trying to word here, the concern of using artists or authors to lend legitimacy to work generated by AI? Like, say somebody writes a book using AI, but then hires an actual artist to do the cover and then attaches it to the book. Does that then make that work legal or copyrightable?
No, but at the end of the day, it's trying to add a veneer, a PR, public relations veneer over something that's a big turd.
Yep.
Right, it's a big steaming pile, but here's this nice little thing on top of it.
We've been seeing a lot of that on Twitter, actually, in the publishing sphere of writers and authors using AI to make their book covers, and a lot of self-publishing authors are justifying this as, well, I don't have the money to hire somebody to make a cover, so I'm just going to use AI. And my response to that is like, so you wrote it, you didn't write it, it's AI too. So if you have an AI cover, I'm just going to assume the inside is AI written as well.
And I mean, at the end of the day, you can get, I'm dead serious. Like, there's not a person in this room when they were younger or inexperienced who didn't do a piece of work for like $100. There is not anyone out there who can't get a real artist to make a real thing for a reasonable amount of money for someone who doesn't have a lot of money. That's not a true statement.
Yep.
Right? Yeah, it's exactly what it is. It's an excuse, not a reason. Or it's a reason, not an excuse. Great Amazon Heist, thank you. You should all look it up. I can't wait to see it. I'm dying to see this documentary. Yeah. Any other questions? I'll keep going. Yeah. I don't know. I don't want to keep speaking for you. Can you speak up a little bit? It's I'm going to let you answer that one. because I'm going to say no because capitalism bad because I don't trust any. I'm not. I pay lip service to, and I keep making a joke, but at the end of the day, companies exist to make money for themselves. They are the definitions of as entities in and of themselves. They are the definitions of sociopaths because they have no goal other than their own well-being, right? Like, I don't. There is not a bone in my body that believes Microsoft when it tells me it's not mining my data. When I use Word to write a contract for a client, the new versions of Word when it finishes your sentence.
I think there are some companies where their goal is privacy, and like Proton Mail is a good
Sure.
example where they have third-party, globally recognized security companies confirming that like that they're following best practices to what our technology is currently.
But are they lying? Like Proton Mail, I probably believe. Like there are a couple of individuals that I you know, like like tech companies that focus on security, data security, privacy. But again, they're not offering products that I'm going to use in my daily life.
Yeah, I don't know the answer to that question. I'm so sorry. I don't know.
So, did they, companies like Meta and Twitter and all that, if they have their own open AIs, wouldn't they be able to put in their TOS that they can use images that anyone uploads for any reason?
They do.
Yeah.
And so then, would, is that grounds for the lawsuit to be thrown out, or?
They can use it however they wish. They cannot relicense it, repurpose it. They can't put you in like. And if you read it, those terms of service say we can use it as we wish to deliver the services to you and any other reasonable thing, right? Taking your intellectual property and making derivative works from it, that is not the use for which you've given them the IP. The IP is that IP, unchanged, whatever. The argument is when you take it and put it into a database, everything is a derivative work of the work that was in that database to begin with. So it's a good question. It's a very good question, actually, because those terms of service do say they can do whatever, but it doesn't give them the right to make derivative works of that for the most part. And of course, you know, I could be completely wrong because I haven't looked at the meta terms in like a month because everything's changed in the last couple of months. It's just going to keep getting worse and different. Different. I should stop saying the word worse, but it is.
I wanted to mention there's something called Glaze. Has anybody heard of it? It's this technology where you upload your work, and then there's a filter put onto it that deters scraping technology, but also poisons it too, which is fascinating.
It like points it to like wrong things or
yeah,
something.
so it like.
Does it work? Have you used it?
I've heard it works. I haven't worked with it personally because I don't have a desktop computer for that, but it does require that. But I have heard amazing things about it, and it is like currently really the only defense we have right now.
And it only works on new stuff because like everything that's been out there has already been trained on. But if everybody uses something like that moving forward, I mean, I don't know how long it'll be before they break it, but
they're trying to break it.
Of course
they're working. They have. Yeah, I'm not surprised.
They are trying to update, like they keep updating it. It's a fight.
Yeah.
right.
Yeah.
I mean, it's the difference between, you know, hackers and your security of your system. Everything's just.
Information security.
But it's something for now until we have regulation in place.
Well, it makes it more difficult for them. They
Yeah.
have the resources for it. Try and break it to be able to further their product.
Fun times.
The yeah, please do our call to action.
Yep.
Right to the Copyright Office. Also, please stay.
Almost done.
Cool. Please stay involved and abreast of changing situations. Like right now is the opportunity to actually make impactful change, because if we don't right now, we're not going to have an option. There will be no other time for us to have any meaningful response to this. It's right now. So please don't become complacent and don't get hopeless either. I have a lot of information I cannot share, but I'm very
hopeful about it.
I'm very hopeful. It's going to be a long, arduous fight, but I think it's like, personally, I feel like it's the fight of my life right now, you know? And I just really hope people stay optimistic and you know, fight for our work, fight for our humanity, because that's where we're at.
Real quick, for the comment cards, I'm assuming no, but can minors
Sure.
submit
Why
them as
Yes,
well?
and you don't have to be a U.S. citizen either.
Yeah.
Nice.
I have a bunch of Brit friends who are voice actors who have all submitted. So
Yep. That's awesome.
yeah.
That's excellent.
Oh yeah.
Oh yeah. All of them. OpenAI has already like they've all submitted like and these huge screens. Well, remember it has to be by a real like a verifiable human being, right? So they're not just having a bot do these entries. And I guarantee you there are a bunch of idiot prompt jockeys out there who are like, I want copyright protection for my prompts, but I should be able to prompt anything I want. Okay. But yeah, so yes, open forum means anyone can submit, and there will be some idiots who submit.
But hopefully.
Hopefully, all of you will
More of
submit
us.
on.
Yeah.
Yeah, exactly.
There's more of us.
Anything else? All right, go enjoy the rest of your Illuxcon.
Awesome. Thanks.
Thank you, everybody, for attending. Oh, that's all good. Thank you. So I'm gonna float this right now. We're gonna do it again next year, and you're gonna tell me what's going on with the lawsuit when you win.
Oh my gosh, yeah.
Let me turn this off real quick, and then I'll.